What list, Lordship?
Yes.
Lordship, I think to mention item number 14.
Okay.
Lordship, I've sent for waiting on the affidavit, waiting for that. In the meantime, respondent number 3, which is also withdrawal party in the present case, Nagaland Public Service Commission. So further notice has to be issued to the respondent number 3.
Let us wait. Let us see the office note and pass order. Okay.
Okay.
We'll adjourn, but wait for some time. Okay.
So, Lordship, I beg to mention from the hearing list, Your Lordship. Item number 24, Your Lordship. Your Lordship, the letter was heard on 20th of May on this May 2025, Your Lordship. However, on this day, there was some actual disputes between the parties. So the court had directed the state respondent to file a report, particularly with regard to the calculations,
Yes.
statements.
Yes, yes.
The petitioners are claiming that they've been given less salary for some few months, so there's some disputed facts. So state respondents were directed to file a report. So I've received the report, so I would like to file the report in the form of an affidavit
Okay.
So
When it was directed?
on 20th of May 2025. 05/2025.
Okay.
So since I've already received the report, I would like to file this in the form of an affidavit. So Your Lordship, may kindly grant some time to file an additional affidavit.
Okay.
Let's
Mr. Nalde, non-government advocate, submits that as directed by this court on 28/5/2025. She has received a report from the department regarding the calculation to which she want to bring on record by filing affidavit and placed for some time, to which the Lana counsel for the petition. Miss,
Okay, so
There's no
appearing on behalf of my son.
okay, appearing on behalf of senior Senior is submitted.
Yes,
Okay, there's no objection. Accordingly, the prayer agreement list is matter after
Your Lordship.
2 weeks. Okay.
Much obliged. Much obliged, Your Lordship.
So, Lordship,
Yeah.
I beg to mention item number 23. The leading counsel for this petitioner is having some personal difficulties, so your Lordship may kindly list this matter after 3 weeks.
Okay, Lemapa. No. Okay, who is the leading counsel?
Welcome.
Makam. Mr. You are Mr.
Lelam Thong Pim Chongwar.
Hmm?
Lelam Thong Pim Chongwar.
Okay. Some is that the leading counsel, Mr. H. Mukam, has some personal difficulties today and therefore pray for adjournment, to which the Lana counsel for the respondent has no objection. Accordingly, the prayer is allowed. List this matter after when do you want?
3 weeks. my Lord.
After 3 weeks. Okay.
Much obliged.
Thank you, Sir Lordship.
Yes.
Lordship, I beg to mention hearing item number 21 and 22, Lordship. Your Lordship, in item number 22, Lordship, I have not found the affidavit of petitioner.
In 23, you have filed, 22, you have filed affidavit.
In 22, I have not found, Lordship.
Not yet.
Not yet. And 21, Lordship, it's been handled by my colleague, Lordship.
Okay, so you have not yet filed affidavit. Why it has been listed
Yes, Lordship.
for hearing? Okay. Ms. Chen,
And Lordship, this, item number 22, Lordship, there are several petitioners, Lordship, and out of which, petitioner number 30, Lordship, he has filed a separate writ petition, that is, writ petition number 155 of 2022, Lordship. So it can be delivered from this.
okay,
from this-
what is the stage in that, of that writ petition? That is also in the hearing stage.
No, Lordship. It's in, writ petition number 172 of 24, Lordship.
Not listed today,
It's listed here, Lordship.
or listed
Right
here.
now.
Which item?
Item 22, Lordship.
Oh, no. You said that petitioner number 30 has filed separate.
Yes, sir. Separate with petition, Lordship.
Where?
And this is,
Number?
number 21.
Oh, item 21.
Item 21, Lordship, yes.
Okay.
May, Mr. Lordship,
Yeah.
I may be granted 3 weeks to file IA.
IA for what?
To remove petitioner C. Pukam. He's already a party to WBC 172 of 2024.
Which one? In item 31.
Yes, Your Lordship.
He is also party in 22.
172 of 2024.
Item 22 means 172. There also he is a party.
Yes, Your Lordship.
This is regarding the same matter.
Yes, Your Lordship.
So what do you want to file now?
IA
IA for IA?
to remove petitioner C. Pukam Konya, that is WBC 155. Item 21.
To remove
Yes, Your Lordship.
his name.
Yes, Your Lordship.
Okay. Miss
Seiko.
Nana counsel for the petitioner submits. No, here from 155. In 155, you are also party, and from this 155, you want to remove your name.
Yes,
You-
Your Lordship.
Okay. Okay, Miss, because counsel for the petitioner. Some is that the petitioner number, petitioner number
30, Lordship.
30.
30. The petitioner number 30 is also petitioners in WPC number 172.
Your Lordship, C. Bukam Konya is WBC 155 of 2022. So we will be filing our A to remove.
Yes.
Yes.
So why you want, why his name be removed
Your Lordship, since it's already a party,
in 172?
once
That is what I'm saying.
petitioner number
172. Therefore, she wants to file IA. To strike of his name as a petitioners in this writ petition. Pray there, and praise for some time. Okay, Ms. Chen, in WPC number 172, 2022, also submits that she is yet to file affidavit in opposition on behalf of the state respondent and prays for some time. In view of the above, the prayer of the petitioner to file IA in WPC number 155 is allowed. Let the matter be listed after 3 weeks. Okay. Okay.
Okay.
And in the meantime, Ms. Cheng shall also file affidavit in 172. Okay.
Motion.
On behalf of the state respondent. Okay.
Lordship, regarding item 21, my senior counsel is not here, so if your lordship can grant us 3 weeks time.
Item 21.
21, your lordship.
So, okay, it will be listed after 3 weeks only.
Oblige, your lordship.
Okay.
Lordship, I also like to mention item 19, Lordship, on behalf of which you want me, if, previous time you continue, Lordship. Item 19.
Who is for the petitioner? You're for the petitioner.
Yes, Your Lordship.
No objection.
Lordship.
Okay, Ms. Cheng, Lana Government Advocate, appearing on behalf of Mr. P. Jimomi. Praise for adjournment of the matter. For how much?
2 weeks.
2 weeks. The prayer not objected. Accordingly, the prayer is allowed. List this matter after 2 weeks. Okay.
Yes, your lordship.
Yes.
Lordship, I beg to mention, item 5. The lordship here, I want to file the additional affidavit. So may I pray this matter be listed after 3 weeks?
Additional affidavit.
Yes, your lordship.
Otherwise, this was ready. This is ready for,
There are
to be
some
listed
document
for-
to be placed on record, your lordship, for the
okay.
certification.
You want to file additional
Additional
affidavit?
affidavit.
Okay,
The petitioner, Lordship.
you're for the petitioner. You are Miss
Yes, another one.
Lana Counsel for the petitioner is present. Stop. Miss Mary, Senior Government Advocate, wants to file additional affidavit on behalf of the state respondent and prays for how much time?
2 weeks time.
3 weeks time. The prayer not objected. Accordingly, the prayer is allowed. List this matter after 3 weeks.
Oblige.
Okay.
Yes, Lordship.
Yes.
Lordship, I beg to mention item 6, there's a consensus period between both the parties, Lordship. Lordship, if the matter can come up on 4th of August for hearing, Lordship. Difficulties.
This, I think, is ready for hearing.
Yes, Lordship.
It will be listed for hearing then.
Yes, Lordship.
Okay. Heard Mr. Paseko Fotu, Land Council petitioner. Also, Mr. Kulnu, Jed Kulnu, Zed Kulnu, Land Council appearing on behalf of the respondent, staff. The pleadings are completed accordingly. Let this matter be listed for hearing after 4 weeks.
On 4th of August.
4th of August.
Yes.
Okay, okay. The matter is, okay, the matter, the pleadings are completed and the matter is ready for hearing. So on the prayer of both the land council for the party, let this matter be listed on 4/8/2025. Okay.
Lordship is an interim, can you interim continue,
The
Lordship?
interim order passed earlier shall continue till the next date of listing. Okay.
I please, your lordship.
Yes.
Lordship, I'd like to mention item 13. Lordship, this matter was, I speak for today, our lordship, my senior has some personal difficulties today. Lordship. So I pray that let the matter be listed at the convening of this honorable court.
Who is
Except
for the
today.
respondent is,
But if the
Lordship,
respondent,
I'm one of the respondents.
Okay.
they may prefer fixed date now.
Fixed date. Okay. Mr.
Noklay yang banyak.
Knockling Konyak. Sam is that he is senior. Lana Council appearing on, sorry, Lana Council. Sam is that he is senior. has some personal difficulties today and therefore pray for adjournment. To which the Mr.
And Borough.
and Barolana Council for the respondent has no objection provided the matter is fixed on,
First of all.
okay, 1st of August. Okay. Mr.
Lordship, I'm appearing for respondent 9 and 10.
Okay,
Lordship, there is
From
an interim.
okay, just a minute. Huh? Ms. Chen for appear on behalf of the respondent number. Okay, it's the respondent. And Mr. C.D. Rungsum for the respondent. You are for respondent number 9.
9 and 10. Lordship.
Respondent number 9. Okay, so is prayed
Nine.
for this matter on 1st of August. Okay, 1/8/2025.
Lordship, there is an interim.
Para the interim order passed earlier shall continue till then. Okay.
Deeply obliged.
Deeply obliged, Lordship.
May I please, your lordship?
Yes,
Lordship, I beg to mention item number 9, your lordship.
item 9.
Lordship, I may be allowed another 3 weeks time to file my reply.
Okay. Miss
That's to your lordship.
Esther, Land Council for the petitioner. Prays for further 3 weeks time to file affidavit in reply to the affidavit in opposition filed by the respondent. The prayer not objected. Accordingly, the prayer is allowed. List this matter after 3 weeks.
Much again.
Okay. They have not yet filed reply. Yes,
And please, your lordship, I'd like to mention item number 20. The matter can come up after 3 weeks.
J. So no objection, Libby.
Yes, lordship.
Okay. Miss
Asarutsa.
Land Council for the petitioner. Prays for adjournment of the matter for 3 weeks, to which Miss Levika, Land Government Advocate for the state respondent has no objection. Accordingly, the prayer is allowed. List this matter after 3 weeks. Okay.
May I be pleased to mention item number 8, your lordship, not to mention. Item 8.
Not yet filed.
Yes, your lordship. So I received the instruction this morning, your lordship. So another 3 weeks will be granted.
Lordship, there is an interim.
There is nothing. Okay, stop. Miss Levika, Land Government Advocate, submits that she has received the instruction and prays for further
3 weeks.
3 weeks time to file affidavit in opposition. To which Mr. You are Maruf.
Lordship.
Yes, W. Maruf, Land Council for that petitioner has no objection. Accordingly, the prayer is allowed. List this matter after 3 weeks.
Interim, Lordship.
Para, the interim order passed earlier shall continue to the next date of listing. Okay.
Please, your lordship, I beg to mention item number 11 and below.
I,
Your
Yes.
lordship, kindly grant 2 weeks time to file wakalat and IA, objection to the IA.
okay, you are for the respondent.
Yes, your lordship.
Who is for the applicant?
Lordship, I'm for the.
State has filed.
Yes, yes.
Okay. Ms. Shukri, Land ADG. There is not, Advocate Jan is present. Huh? Miss
Manashino.
Land Council, appearing on behalf of the opposite party, respondent. Opposite party. Prays for
2 weeks time.
2 weeks time to file wakalatnama on behalf of the opposite party. The prayer is allowed. List this matter after 2 weeks. Okay.
Much obliged. Please, Your Lordship. Lordship, I would to mention item number 3, my lord. Lordship, here, I'm filing my reply to the affidavit filed by the respondent number 4 and 5 today, my lord. So, Lordship, after this, the pleadings will be completed after that, my lord. So if this matter can come up for hearing in its usual course, my lord, I'll be filing it today itself, my lord.
Okay, who is for the petition? Okay, who is for the petitioner?
I'm
You
for
are
the
for-
petitioner, my lord.
You are for the petitioner.
Filing reply to the.
Oh, reply.
Affidavit, filed by the
You are
respondent
filing
number 4
reply
and 5.
today itself.
Yes, ma'am.
Okay. Miss Luzina,
Yes,
no?
yes.
Land Council for the petitioner. Submitted. She is filing affidavit in reply today itself. And will serve a copy to the Land Council appearing on behalf of the respondent during the course of the day.
Yes, ma'am.
Okay. And since the, okay. Mr. You are appearing here.
Lordship, my colleague, KV,
KV.
yes. But I told the state,
Others-
I've already filed it. It's,
Okay.
yeah,
Already filed.
yes, sir.
Okay. Mr. Angami appear on behalf of Mr. K. Angami, huh? For the respondent, state respondent
For respondent 6, 7, and 8.
and Mr. Isin-law.
Yes, my lord.
Isin-law him appear on behalf of the respondent number 6, 7, and 8, and Mr.
Your Lordship, Azizo can say, on behalf of respondent number 4 and 5.
Okay, and K appearing on behalf of respondent number 4 and 5, and
Your Lordship, I'm appearing for respondent number 9.
Miss
Sigmo.
For respondent number 9, stop. Since the pleadings, you have not yet filed.
Lordship, for reply to respondent number 4 and 5.
Hmm.
In respect to the other.
Okay,
respondents
the
that we
reply
have-
to respondent number 4 and 5
Yes.
only.
Yeah.
Okay, then in her case, reply to the affidavit filed by the respondent number 4 and 5, mention 4 and 5. Okay, today itself, and a copy shall be served within the during the course of the day. Stuff like that. Since the parties are being represented, duly represented, and the pleadings completed, the matter be listed for hearing during hearing in usual course. Okay,
Obliged, Your Honor.
Obliged, sir.
Lordship, if I may be allowed to make a mention of item number 2 also, my lord. Lordship,
this is also ready for hearing.
no, my lord. In fact, I have just received the affidavit filed by the state this morning, my lord. So if I may be granted some time to go through the affidavit and file my reply if necessary, my lord.
Okay, Ms. Lozina, Land Council for the petitioner, submits that she has just received a copy of the affidavit in opposition filed by the state respondent, and prays for some time to go through the same and to file affidavit in reply if
Yes, my lord.
If
If necessary.
necessary. Okay.
Granted 3 weeks time, my lord.
Stop. Is prayed for, comma, list is matter after 3 weeks.
Lordship, there's an interim here. If
Para, the interim order passed earlier shall continue till the next date of listing. Okay.
Obliged, Your Honor.
Thank you, Your Lordship. Lordship, I beg to mention item number 7, Lordship. Lordship, I have taken consent from the state respondents. So let the matter may be listed after 3 weeks, Lordship.
Okay, Mr.
Nabla M. Konya.
Yes, Nuklo and Konya. Land Council for the petitioner. No, affidavit not yet filed.
Yes, Your Lordship. State yet to file.
No, state is not seeking adjournment. Where state yet to file affidavit. Mr. Mojo for respondent number 5.
For the AG lordship.
Have you filed affidavit?
No, lordship, I'm not filing an affidavit because.
You are not
the issue
filing.
is between the petitioner and the government.
State. Okay,
Yes.
government has not yet filed. Yes, Miss Libika.
Lordship, on behalf of AIME, Lordship, I note that she is indisposed. So, Lordship, another 3 weeks to be granted.
Okay. So Miss Libika appearing on behalf of Ms. AIM, Atlantic Council for the state respondent. She has not yet filed. We'll grant 4 weeks then. Pray for further 4 weeks time to file affidavit in petition, to which the Atlantic Council for the petitioner has no objection. Mr. Mojo, Atlantic Council appearing on behalf of the respondent number 5 submitted his submits that respondent number 5 is not filing affidavit. Okay,
So,
as the dispute is between the state and between the petitioner and the state. Okay, is prayed for, list by the parties, list this matter after 4 weeks. Okay.
For motion, item number 1.
Yes, my lord.
Yes.
Lordship, this is a covered case where similarly situated graduate teachers in writ petition 174/2018 approached this honorable court. And by judgment order dated 25/2020, they challenged the reduction of their salary. A reduction of their salary that was fixed pay of 31,350. That was the fixed pay. They were recruited through recruitment process. And in 2018-19, the central government merged erstwhile SSA and RMSA.
What is, okay, SSA and RMS,
RMSA,
You are-
into Samagra Shiksha.
and you are,
And we were RMSA
okay,
appointed.
okay,
Now, what happened is, the central government reduced the salary that was 31,350. Fixed for RMSA teachers was reduced to 25,000. So this 435 similarly situated persons approached this honorable court, and while 31,350 was restored by the single judge, they were denied scale pay because it came to light that the post 627 posts were created by the state government, and they were appointed in that state government post created sanctioned post. So they approached this honorable court for granting them their post creation payment scale pay. Now restoration was given to 31,350 by the 11th single judge. So the petitioners were aggrieved and they approached this honorable court in writ appeal number 9/2020.
writ appeal,
In writ appeal to grant them
Scale.
post creation
Scale.
payment salary.
okay,
And this honorable court, by order dated 16/3/2022, upheld that the petitioners are eligible for their post-creation payment. Against this, the state government went and filed SLP before the Honorable Supreme Court. And on 26/2025, the Honorable Supreme Court has dismissed the SLP filed by the state government. Now, Lordship, we are approaching this honorable court because we could not join the 335 in the previous writ petition because at that point of time, 528 candidates were selected and appointed, and 198 was kept in waiting list. So we, now the present petitioner 84 are from the waiting list. Subsequently, 111 were selected and they were appointed as RMSA teachers and posted to different schools all over Nagaland. Now what has happened is, at the time when the reduction of their fixed salary was done, this 111 in waiting list, our salary was not reduced. That's why we did not join, though all the cause of action, everything is all the same. We did not join the first writ petitioners because our salary was not reduced. We, the petitioners, 111, our salary.
It was not with the notification.
Yes, Lordship.
So the notice was issued to the other, the petition.
Yes, other petitioners.
Not to you.
Not to us.
But then the notification covers both.
No, notification did not cover us. It covered only the 435 that approached this honorable court,
Okay.
and their salary was reduced. Whereas we, the petitioner, our salary was not reduced and the impugn notification did not cover us. So we could not join the first writ petition, that is 174/2008. However, and since this 335 against 335 giving post-creation payment, the state government filed SLP. Since it has been dismissed, Lordship, now what has happened is on 12/6/2025, we thought, we the petitioner, since principle of law applies to all the similarly situated persons, we thought that since the similarly situated person have been granted scale pay
Already granted.
granted in the writ appeal, that has been upheld. My lord will kindly come
No,
to.
subsequently, whether the government has passed any order?
Not yet.
Not yet.
Yeah, it is recently the Supreme Court dismissal was recent on 2025. So it is under process. We have submitted all the documents to the state government. Lordship will kindly come to the writ appeal judgment order is at page 184, annexure K. Operative portion is at the page 232, Lordship. Operative portion, the last portion is 232. I may be allowed to read out the last paragraphs, 19 and 20. That is operative portion, Lordship.
Yeah.
If my lord has seen it. 19. While deciding the issue, the learned single judge failed to appreciate the aforesaid facts that the petitioner and their counterparts who were getting scales of pay are equally placed and there is wholesome equality between them. The learned single judge rejected the prayer on the basis of the contract bond signed by the petitioners and delay in approaching the court. Inasmuch as the date of advertisement, the posts were not created and scales were not given. Accordingly, in view of the aforesaid discussions, findings, and decisions, this court holds that the petitioners are entitled for scale of pay at pay band of rupees 9,300, 34,800 with grade pay of rupees 4,200 PM. Accordingly, it is directed the state respondents to grant such scales of pay to the petitioners forthwith. 20. It is made clear that this court is not determining the issue regarding the decision of the state, whereby the other teachers excluding the petitioners were brought under state cadre with benefit, including NPSM, being not under challenge in the writ petition and not determined. 21. With the aforesaid terms, this writ appeal is disposed of. However, no order as to the cost. So, against this judgment order, the state filed SLP, that is annexure L, page 334, Lordship. Next. Here is the dismissal order. My lord can kindly see that Amos Sepp and others respondents, and this was passed on 25/2025. Date. This matter was called on for hearing today. Now, my lord will kindly come to the next page. 335. Upon hearing the counsel, the court made the following orders. 1. We are not inclined to interfere with the impugned judgment and order of the High Court. Hence, the special leave petition is dismissed. Interim order granted earlier stands vacated. 3, pending applications, if any, shall stand disposed of. So this was passed on 20th/5/2025. Now, Lordship, since we did not join in the previous writ petition, the principle applies in general, and now we are before this honorable court. We are still getting 31,350 fixed pay. So we are also bringing before this honorable for extension of the same benefit to the petitioner's lordship. What has happened is on 12, my lord will kindly come to page 249. Last page, annexure T. This month itself last month, 12, that is 12/6/2025. This undertaking was issued. Immediately, we filed this writ petition on 26/6/2025. However, it was not listed. So it was kept pending on only today it has come up for motion. In the meantime, Lordship, we have prayed for stay of this undertaking. That is, my lord can kindly see, undertaking is very inappropriate. What has happened is, these are the format. This is issued to designation of PT, PT Hindi, GTM, GT Science, GT General, GTSS, and GT English, GT Language, and GT Hindi against the erstwhile dash scheme SSA, RMSA, CSS Hindi on the basis regular mainstream, regular non-mainstream, ad hoc, fixed, contract, appointed, engaged by the specified directorate, school education, or Nagaland Education Mission Society in the scale pay, fixed remuneration of specified pay band and grade pay or fixed salary for other categories at specified place of posting, SDO, DEO, bearing other so and so. Now here, Lordship will kindly come to last condition. This is the condition to be filled up by the petitioners. I do hereby undertake to refund any advance salary paid to me by the State Department of School Education in the event of salary migration to the SNA SPARSH system. This undertaking shall be applicable solely for the period commencing from 1st March 2025 until the date of implementation of the SNA SPARSH system. I further authorize my drawing and disbursing officer DDO or head of office to recover the said advance salary paid to the state government Department of School Education in the event that I fail to make the refund voluntarily. This is very opposite and contradictory, Lordship. School education in the event that I fail to make the refund voluntarily. I declare that the above undertaking is made of my own free will, in full consciousness and sound mind. So this is a contradictory undertaking that was issued to the petitioners. However, Lordship, while this matter was pending, our salary has been till date held for 4 months. The petitioner's salary, including other RMSA, SSA teachers. Now, while this, after pending of this writ petition, in the meantime, Lordship, it has become very hard for the petitioners.
Why
Because
the salary was held? Because this is only talk about the reduction. This undertaking,
Lordship,
reduction 31 to 25,
Lordship,
and then since March,
they are saying that
this is applicable, made applicable only after I think, from March only. is it?
Yes, Lordship. They are saying that we will be paid our pending salary. In case of this sparge that is implemented, again, we have to refund the salary that was paid to us. That was the undertaking. However, in the meantime, Lordship, we are not pressing this interim stay.
Okay,
Today, we are not, it will be on merit.
okay.
So we are not
So
pressing
then
this.
we'll issue notice.
Yes, Lordship.
Yes,
Your Lordship, I will be for 1 to 4.
okay.
Respondent number 6 is the Union of India Lordship.
Your Lordship, I will be only for 1, 2, 3, and 4.
1, 3, and 4. Okay.
Page number 6, cost item, page number 6.
Oh, okay. State mission, songs, and which for 5? 6 is union.
Yes, Lordship.
Okay. Hardness, Z Zimomi. Land counsel for the petitioner.
Petitioners.
Petitioners. Okay, your prayer is for setting aside the undertaking. So you're not
Yes,
pressing now.
that was also it.
So your basic claim is that provide a petitioner post creation.
Yes.
Pay.
Yes. Other similar.
So this is first time that you are coming before the court.
Yes,
Otherwise, those were filed by only 435.
Yes,
petitioners, but you were not there.
we were not there because our salary was not reduced to 25,000.
Okay, no need to bring it now.
We were appointed on 2nd June 2016. All the petitioners.
Second June.
2nd June.
And you were the you were the wait list persons only,
Yes, Lordship.
not the person appointed.
First, yes,
And the persons who were appointed first have
approached the
approached
this
the
honorable court.
and then their salary was reviewed.
Reviews.
Directed to the regime. Okay.
Exactly.
So not yours.
Not
And
ours.
you were subsequently or after how many days or years you have been
No.
appointed after?
After 3 years,
After
after
three.
3 months,
After 3
after
months?
3 months, we were approved. Lordship will kindly come
No,
to.
no, these 435 were appointed in the year 2020,
Yes, 2016, 2016.
2016, and you were appointed on.
On 2nd June 2016.
You were also appointed.
Yes,
on
yes,
16.
yes. Yes,
So
after their
subsequent-
appointment, right after their appointment, we were also appointed. Our approval is at annexure E 117. Lordship. My lord,
100 and
117, page, yes.
what is that? 117.
117 is approving 111 GTs
Okay.
to be engaged by the Directorate of School Education. Then Lordship will kindly come to page 121.
No need to provide all those. We'll issue notice only.
Lordship.
Okay. By filing this petition, the petition. Plain. Salary. Creation. To the pay for the post creation. Pay post creation fair ban of rupees 9,300. For the 4,000. Which rate pay is rupees 500. 5,400. What creation notifications are there? Okay. It's 113. It is committed. It is committed. Based on the advertisement. How many creation was?
627,
Okay,
page 113,
113.
page 113, C2. Approval was given by the cabinet on annexure C, 111.
111.
If my lord will kindly see 111 page C, this was cabinet
The total
decision.
creation was how much? How many posts were created?
If my lord will kindly read out, there is the cabinet 627.
Okay, just a minute.
That-
It is submitted that by an order dated, which one?
5th October 2015,
5/10/2015,
the cabinet approved
the cabinet approved for creation of
627
627
posts of
posts
graduate
of
teachers
graduate teachers and language teachers.
with pay band of PNR department.
Where do we find that pay band?
Pay band is at page 112. Roman 2.
Okay, 627. Okay, postgraduate teachers. In the GP rupees 9,300 dash 3,000, no, so 34,800 plus GPay rupees 4,200.
Yes, officially at page 113, Lordship. C2, where the
What-
governor of
what is
Nagaland
this?
created the post.
This was then created on 28 only.
28 October 2015. The previous one was approval by the cabinet. And this is the official notification,
And which was notified on 28.
28 October 2018, 2015,
2015. Stop. Huh?
Roman 2. We were appointed against Roman 1. The first Roman 1, 112
The advertisement was
vacant
issued
posts.
and altogether 435 graduate teachers were appointed. And how many were in wait list? You
Lordship,
were in 435 was appointed, and how many were
no,
in the wait list?
Lordship, a total of 528 was.
Okay.
Only those who approached the court are 435.
Okay, okay.
Otherwise, appointment was 528
Okay.
candidates.
Then 528
28 candidates were appointed, and
candidates were appointed,
198 were kept in
And-
waiting list.
198 were kept in the waiting list.
Out of which
Out of which-
111 were engaged by the Department of School
Out of
Education.
which 111 were engaged by the Department of School Education staff,
including the petitioners.
including the present petitioners staff. Para. By which notification it was sought to be reduced?
Reduction is, Lordship will kindly come to 125. Annexure H. At serial number 4. Revision of pay under Samagra Shiksha. This is 27 August 2018. Graduate teachers at serial number 4.
That appointment, appointed in earlier sentence, appointed. It was on contract basis only,
Lordship.
contract basis at
At a fixed pay of 31.
fixed pay of rupees 31,000, how 31,315 rupees per month. Stop, para. However, by an office letter dated 27/8/18, the respondent sought to reduce the monthly salary of rupees 31,315 to rupees 25,000. Staff, being aggrieved, the
Others similarly situated.
others, being aggrieved, 435 similarly situated graduate teachers approach this court, and by judgment and order dated 16/3/2022. No, not 16/3/20. Where is the judgment of the single judge?
Judgment and order is 25/2020. My lord will kindly come.
Well,
to
judgment and order dated 20/20,
5/2020.
5/2020. The said notification for reduction was set aside. However,
Scale pay not granted. Scale pay was not granted.
however, scale pay was not granted. Stop. Being aggrieved, the petitioner approach, petitioner filed writ appeal number 9/2020. And by an order dated 16/3/2022.
Yes, lordship. The division granted, division bench granted,
The coordinate bench
scale pay,
has granted,
post creation pay bands.
directed a state respondent to grant the post creation pay band of rupees 9,300 3,400, sorry, 34,800 with GP of rupees 4,200 per month to the petitioners. Start. Against the said order, the state respondent filed SLP before in the Honorable Supreme Court, and by an order dated 20/5/2025, the said SLP was dismissed. Stating not inclined to interfere with the judgment and order passed by the High Court. Stop. The case of Sopera, it is submitted that the present petitioner did not join the similarly situated persons in the earlier writ petition, as their salary was not disturbed. As their salary of rupees 31,100. What was the salary?
31,315.
Was not disturbed. However, they are similar, they are okay. It is submitted that the present petitioners were also selected and appointed through recruitment process from the same advertisement, along with 435 petitioner applicants in the aforesaid writ petitions. Therefore, the petitioner also seek the same relief identical to the petitioner in WPC number
Writ appeal, writ appeal,
writ appeal
Nine. obliques 20.
number writ appeal number 9 to 2020.
2020.
2020.
Lordship.
Okay, para. Issue notice. Returnable by 6 weeks. Start. Since Miss Libika appears and accepts notice on behalf of the respondent number 1 to 4. No formal notice need be issued to the said respondents. You need the extra copy also?
Yes, sir.
Okay, however, the petitioner shall serve extra, the requisite extra copies to the Land Council, Miss Libika, during the course of the day. Staff. The petitioner shall also take steps upon the respondent number 5 and 6 by a registered post with AD within a week from today.
Within 3 days, Lordship.
Within 3 days?
Yes.
Okay, within 3 days from today, start. List this matter after 6 weeks.
Lordship.
Okay.
Can it be 4
4 weeks, okay, make it 4 weeks then. Is it okay? I thought there is a lot of petitioners.
Lordship.
Okay,
Obliged, Lordship.
For admission, item number 4.
pen.
May I please, Lordship?
Yes,
Lordship, I've received the affidavit filed by the state. And Lordship, Finance Department is necessary in this petition, Lordship, and
okay,
I have not included them in my writ petition.
okay.
So kindly grant me some time to file an IA for including the Finance Department.
Okay, probably. Earlier you made a prayer to file reply. Affidavit in
If
reply.
necessary, yes, yes, yes,
You want to file,
yes, yes.
you want to file that, affidavit in reply also?
No, he has not filed, Your Lordship.
I have not filed.
Reply, he has not filed
No,
reply.
you want to file reply also. Okay. Mr.
Lakney Pom, Lordship.
Lakhney Phom, Land Council for the petitioner, submits that the Finance Department means who is the authority in Finance Department? whom you want to implead?
The finance department,
Finance department?
yes.
The finance department is represented by some other person? Okay. The
Commissioner
finance
and
department is a necessary party in this writ petition, therefore, the finance department is necessary party. However, due to oversight, they could not impede the finance department, therefore pray for allowing him to implead the finance department as a
Respondent number
respondent
6.
party. The prayer is allowed. Okay. The Learned Counsel for the petitioner also prays for further time to file affidavit in reply to the affidavit so filed by the state respondent number 1, 2, 3, 4, and 5. Okay, stop. Huh? Ms. Libika, Learned Counsel for the respondent, number 1 to 4, 5, is present. He is prayed for, is prayed for by the Learned Counsel for the petitioner. List this matter after 3 weeks. Okay.
Obliged, Lord.
For admission, item number 10.
Please, Your Lordship.
Yes.
Your Lordship, on the last date, the state was directed to file their AIO.
Not yet filed. Who will represent the state?
May I please, Your Lordship? Your Lordship, my colleague might have overlooked the matter, Your Lordship. If the matter can come, my colleague might have overlooked the matter. Supong Chang, the matter is taken up by Supong Chang, Your Lordship.
Okay.
So, Your Lordship, after 3 weeks for filing affidavit.
Mr.
By whom to Your Lordship for the petitioner?
Learned Counsel.
By whom to?
Okay. Learned Counsel for the petitioner is present. Ms. Libika, appearing on behalf of Ms. S. Chen, Learned Government Advocate, prays for further 3 weeks' time to file affidavit in opposition on behalf of the state respondent. The prayer is allowed. List this matter after 3 weeks. Okay.
For orders, item number 14.
Please, Lordship. Lordship, notice upon respondent number 3 is still awaited.
Yes.
Yes, Lordship.
Respondent number 3 is
Yes.
still awaited. When the notice was taken? State
The
was
last day.
taken? Is
Since-
it, respondent number 3 is a necessary party,
Yes, Your Lordship.
private or any department?
It's NPSC, Chairman, NPSC, Nagaland Public Service
Nagaland
Commission.
Public Service Commission.
Public Service Commission.
Yes, Your Lordship.
Step was taken long back, I think. Or what do you do? What do we do? You want to take fresh steps or just wait for some more time?
Since the previous steps could not be completed, we have taken a fresh step, so it's still awaited.
Okay,
Yes, Your Lordship.
okay. Hard, Mr.
Ali Bozukam, Lordship.
Learned Counsel for the petitioner. The notice upon the respondent number 3 is still awaited. So you have also not yet filed
Now, we are
affidavit.
not yet filed.
Okay,
It is in the process now.
in the process.
Yes,
So how much time it will require?
2 weeks.
Okay,
But Your Lordship, here in this matter, unless the respondent number 3 is properly represented, then there will be some problem in the proceeding. So by any means, respondent number 3 has to be represented.
okay, still awaited. but-
Yes.
Hmm,
So in the meantime, I will be allowed to file a affidavit.
okay, so land AG, huh? Additional AG. Prays for further 3 weeks' time to file affidavit. Huh? Okay, the prayer is allowed. List this matter after 3 weeks. Okay.
Obliged, Lordship.
For hearing item numbers 50 to 80.
Yes.
Please.
Hmm.
So, Your Lordship, on the last occasion, I have submitted up to the report as to why a special inquiry was constituted, and the report thereafter has been submitted. Your Lordship,
You
I
are for
was in-
respondent, you are for respondent number?
Lordship, I'm for the respondent number. The respondent, Your Lordship, is
5, no.
Lordship 1, 2, 3, and 4.
Okay.
As far as the writ petition 88 of 2022 is concerned, Your Lordship.
Just a minute. Huh?
Yes.
This is petitioners. Where is the note jotted down by me? No, no. Need some more. I have noted down some
Lordship.
points submitted by you, but it appears that it has been misplaced.
Lordship, it's okay, I can I can restart again, Your Lordship.
Okay, so and at the same time,
Yes.
you, because it appears that this is a little long.
Yes.
The story is little long one.
Yes.
So you can also file a list of date with a point.
Lordship.
Okay, so
Lord.
then that will help.
Yes.
Otherwise, it's gone.
Yes.
So I may be allowed to start from the very beginning again, my lord. Then.
Okay.
So your lordship,
State is just state is respondent number
lordship,
in 88.
in 88,
Okay.
as far as the WPC 207 and 58, 207 of 2016 and 58 of 2017, your lordship. On the last occasion, I have proved as to how, I have shown as to how these two writ petitions are not maintainable.
Yes, yes. Just a minute. State respondent.
Yes.
Okay, so there was no prayer.
Yes, there was no prayer, neither the document which is impugned is annexed in the writ petition itself.
Annex, eh?
In the writ petition itself.
Okay.
Yes, in the WPC 58 of 2017, the impugned order is not annexed in the petition itself, which makes the petition defective, and therefore it is not maintainable.
Just a minute. In WPC number
58 year of 2017.
impugn order not annexed.
An impugned order not annexed, thereby making the petition a defective petition, and therefore it is not maintainable. In the WPC 207 of 2016, my lord.
Okay, WPC.
207 of 2016.
Hmm.
The restraining order was issued against certain individuals, but the name of the petitioner is not there in the restraining order itself. Now that restraining order is impugned, your lordship, in the WPC 207 of 2016.
No, the restraining order was issued against some person.
Some individuals, other individuals, where the petitioner name is not reflected in the restraining order itself. And therefore, the petitioner is not aggrieved by the impugned order itself.
But he challenged the.
Yes,
Okay.
he challenged the restraining order. The petitioner have got no local standby whatsoever to challenge this. Therefore, this petition is again not maintainable. Your Lord.
Okay, so now comes to 88.
So yes, that leaves us with 88 year of 2022, my lord.
Yes.
Yes, my lord. Now 88 of 2022, your lordship, the petitioner is making two prayers. Your lordship will find it at page 26.
Yes.
The first prayer, your lordship, if I may be allowed to read this.
Yes.
The first prayer is to quash and set aside the impugned special inquiry report dated 31/10 of 2014, the impugned order dated 24/9 of 2018, and the impugned letter dated 25/1/2020. That is the first prayer. And the second prayer is to direct the state respondent to pay land compensation to the petitioner for the area covered by the 111 notice of permit issued to the settlers on the petitioner's land, and further to direct the state respondent not to encroach any further and desist from issuing any more allotment permits against the land encompassed by the special permit 29/3/1971. I wanted to make one lordship submission here. The second prayer is to make compensation for issuing the permit in the petitioner's land. That is what he's mentioned. In the petitioner's land.
The compensation for
Issuing of permit by the
Authority
in the petitioner's land.
yes, from the petitioner's land.
Yeah, from the petitioner's land. So from his land, he has mentioned, Your Lordship.
Hmm.
This I want my Lord to keep this in mind, Your Lordship, as to how he is claiming the land now, and whether he has got any authority over that land or not. Your Lordship. That is what has to be decided in this particular writ petition, my Lord. Lordship. Now, Your Lordship, how did the petitioner, or how is the petitioner claiming this portion of land, which is in dispute now?
No, just one.
Yes.
This is the first question.
Yes.
This first question, admittedly, it was allotted 111.
No. Allotted.
No. Admittedly, 111 land was allotted to the individuals by the government.
By the government.
Okay, and admittedly, this was given to the petitioner's father to cultivate.
Yes.
Okay, that was a permit.
Yes.
Special permit.
Special permit.
Whether before allotment,
Yeah.
that special permit was recalled or revoked?
No allotment has been given, my Lord.
No. Whatever may be, but the special permit was given.
Yes.
Whether that special permit was recalled?
Yes, it has been recalled.
Where?
It has been recalled, Your Lordship.
After recalling only this 111 was issued.
Your Lordship, the inquiry, this honorable court has asked the Deputy Commissioner to constitute a special inquiry committee to see into the disputed land. The special inquiry committee has submitted its report.
No, dispute arises when you allot the private individuals, isn't it?
Dispute arises not only because the land was allotted by the government. Dispute also arises because the petitioner himself has sold.
No, okay. When the petitioner sold, when the petitioner gifted or sold, whatever,
Yes.
whether the government made objection.
Yes, Your Lordship. That is why in WPC 58, 58 K of 2017, a portion of land that has been allotted by the government to an individual came in dispute because the same portion of land was given to another person by the petitioner.
Okay, petitioner has given to another person
Yes.
because he thought that by giving a special permit, he has a right and authority.
Correct. That is his.
Okay, but then my question,
Yes.
just first question,
Yes.
is whether, because subsequently or prior to that, the government, I don't know which one was prior. So whether before allotting to the individual from the land
Yes.
given on a special permit, whether
Yes.
the government
Yes.
has recalled the special permit granted to the father of the
No.
petitioner's father,
No, Your
and
Lordship.
how the state can give allotment
No, Your Lordship.
unless it is recalled,
No.
unless.
See,
Hmm.
Your Lordship.
Hmm.
Special permit is only for the purpose of cultivation. The land is not allotted to the petitioner's
No,
father.
agreed.
Enough time. Your Lordship.
Agreed. It was only a special permit.
Yes,
My small question,
yes.
whether that special permit was
Yeah.
recalled?
It was recalled subsequently, but the issue
No,
is
not
this-
before, not before.
No, not before. But the issue is this, Your
Then
Lordship.
you see,
The-
then,
Your Lordship, see, the land which is in which now the petitioner is disputing to be his, Your Lordship. Whose land it is, Your Lordship? Now, for example, Your Lordship, if it is my land, I have got every authority to give that land.
no, that's different. Because supposing if you give the watch to your friend, keep it. Okay, unless you get it back. You need to get it back from him,
Lordship?
isn't it?
Yes.
If you have given,
Okay, yes.
even if you want to take it back also, but then you have to take permission from him only. Without permission, you can't take it back.
Let us take it another way then, Your Lordship.
Hmm.
I allow my friend
Hmm.
to drive my vehicle. I permitted him to drive my vehicle.
Yes.
Thus the vehicle belongs to him.
Hmm?
Will the vehicle belongs to him? I permitted
Hmm.
my friend,
Hmm.
by the same analogy, Your Lordship,
Yes,
I
yes.
permitted my friend to drive my vehicle.
Yes.
At the end of the day,
Yes.
then my friend says that the vehicle belongs to him.
No.
No, this is the
No,
case.
no,
This is
just-
exactly the
okay,
case, my
okay,
lord.
let us continue. If you have permitted your friend to drive the vehicle,
Huh.
can you take it back without his permission?
Your lordship, at one point.
That amount to theft?
No, your lordship. It
That
is
amount
my
to take-
vehicle. It is my vehicle.
No,
your lordship.
unless you inform him that I'm taking it back, that will amount to a theft.
Your lordship, in order to amount to a theft,
Hmm.
the property should belongs to a person.
No, you have permitted him to drive. He is driving. But without his permission, how can you take it back?
Okay, then your lordship.
Hmm.
Then by that context, your lordship,
Hmm.
what this honorable court is trying to say that because
No,
the
that is
special-
my only query is whether that was cancelled, that was withdrawn, that was whether that is special permit that you granted, have you withdrawn, have you
Yes. Yes.
that I
Some
only
portion
with
of
the view to clarify that only.
some
this-
portion of the land which
Hmm.
we have allotted, to other individuals have already been cancelled.
So let us assume that it was you have allotted without his permission or without withdrawing the special permit. Admittedly, it was allotment was granted.
Your
or what?
lordship, the issue whether I should take his permission or not will only arise
Hmm.
when the land belongs to him, when he can prove that the land belongs to him.
No, you have permitted him.
Permitted him to cultivate
That
only, your
permission-
lordship, not to
that
own the
per-
land.
That permission, we do not know whether he is cultivating or no.
He is cultivating,
But then you
your
have to
lordship, he is
confirm.
cultivating.
He
He
was-
has cultivated, your lordship.
Oh yeah, that is why you have to seek permission from him. Then we are withdrawing this permission.
No, your lordship. Then in that context, this honorable court is trying to say that the special permit
Hmm.
give him the allotment itself.
No.
If that is the issue, your lord, I can place citation.
No. That special permit, before allotting it to someone permanently, you have to withdraw that special
I
permit.
have withdrawn it now, your lordship.
That you prove that.
I have withdrawn it already, your
That you
lordship.
prove. Where?
Yes, your lordship. In fact, your lordship, even the petitioner himself has, I think, annexed that. In this writ petition itself, my lord. Your lordship may kindly come to page 80.
Is
80, my lord.
80.
Yes, my lord. No problem.
Whatever.
No, your lordship, the landowners, who are the actual landowners to the government, they are wanting to take back their land, your lordship. Now I'm in the place. The petitioner wants land, the actual landowners wants land. Where will I go, my lord?
Now there are three owners.
RDB, and I am the original landowner. This is a local application.
You have already given it to the government. The government has given it to him. Now you see, you have given it to the government. Government has given it to him. Now government wanted to take back from him and you want to take back from government.
No,
See,
I'm in the place,
The
now.
vicious circle.
Is transferable.
Special permit
Is transferable. He is claiming over the land of
Okay. may not be.
in view of the special permit that was given to his father. Whether the special permit I can inherit. It's not a house that I will inherit anymore. It's a permit, a sheet of paper.
No, that is why the basic thing is that you have to just withdraw the permission without a permit first.
We have done it, your
So
lordship.
that you have to,
Yeah.
that you have to satisfy the court.
Yes, we have done it, your lordship. Since your lordship is inquiring about this cancellation order, your lordship will find that at page 80
Hmm.
of the writ petition, my lord. May I read this, my lord?
Yes.
This is order dated 24 September 2018. In pursuance to the letter from the Home Department, Government of Nagaland, white letter dated 14 of September 2017, with regards to the special inquiry report on the special permit issued to late Wanshu Konyak for farmland at Tijit headquarters, the permit number such and such dated 29/3/1971 is hereby cancelled with immediate effect in view of the expansion and development of Tijit administrative headquarters requiring all the candidates.
When the allotment to the private respondent, private was given by the government?
Your lordship, prior to this, and the government has subsequently cancelled it to the private
This is cancellation is in the year 2018.
18.
When the allotment was given.
Allotment was given prior to this, and therefore,
Okay.
yes, the government has
So-
cancelled.
So after giving allotment subsequently, you have cancelled.
We have cancelled.
Realize that it has to be cancelled first.
No, your lordship, because, why? Because the allotment that was done is now required by the government also. And therefore, we have cancelled as many as 12 allotment that we have given. I'll prove it, your lordship. Documents is there to prove it.
12 allotment has
12 allotment.
cancelled.
Already cancelled. Not only this, your lordship, though we have cancelled the special permit granted to his father by this order, yet, your lordship, we have allotted a portion of land where the petitioner's house still stand. We have allotted that to him, in spite of the fact that the land does not belong to him. We have allotted that, your lordship. Now that allotment order is also not in challenge, your lordship, in the present writ petition.
No, who will challenge that allotment?
Your lordship, he is not willing. He is saying that this land belongs, the entire belong to him. Whereas the allotment order, where his house stand, is also not under challenge.
Now, who will challenge that?
The petitioner should challenge it, your lordship.
His own.
Yes, your lordship. If the entire land belongs to him, the portion that we are allotting to him
Okay.
is not even under.
Well, when it was allotted?
Your lordship, it was allotted in the 25th of February 2020.
No, this was, cancellation was on 2018.
18. Thereafter,
After cancellation, you can allot.
yes, again, we have
No,
allotted their portion of land where his house stand.
So that means, according to you, he admit that it was cancelled.
Yes.
And after cancellation only, he got
Yeah.
allotment
He is
allotment from the
coming before this
government.
court by not challenging the allotment order given to him, my lord.
Okay. There is a logic.
There is a logic, your lordship, now. I will give more logic to my lord, your lordship. Allow me to explain this.
Okay.
Now, your lordship,
Yes.
I don't have to explain much as far as the special permit is concerned because my lord is well aware of it now.
Just a minute.
Yes.
Okay. Yes.
But for your lordship, just to refer as to what is the meaning of that permit, allow me to take my lordship to page 31.
Okay. Page 31.
Yes, my lord.
Yes.
Now, your lordship,
This is the permit.
this is the permit. Of course, your lordship, the type copy, your lordship, is at page 32. In my copy, it is not quite readable.
Okay.
It is not legible, your lordship. Page 32 is a type copy. I think, your lordship, I'll
Yes,
read from
yes,
this.
yes.
The first para, your lordship, special permit for farmland at TJ. So the permit itself says for farmland.
Yes.
Your lordship, allow me to take my lordship attention to the heading itself, your lordship. Special permit for farmland at TJ. And it starts 3L1 Shu Konyak RCM is allowed, your lordship. For what the permit is given, now it is reflected. Is allowed to continue cultivations of the low-lying areas where he has put under paddy cultivation at Tijit. The line of demarcation will be as follows, your lordship. A straight line will be drawn from a point on Sonari Mon Road as shown in the survey map till it joins another survey map near the private track as shown in the survey map. From the survey mark point, it will run straight south till the line reaches the first line of banana trees, after which it will turn straight northwest till it comes parallel to the point marked on the stamp by me on 24/5/1971. Taking the last point of northwest line, a straight line should be drawn towards south, crossing the marked stamp till it reaches another mark on the dead tree. From this dead tree, a line will continue straight for a few yards then turn southeast and join the now zoomed land. Following the area already zoomed this year, a line should join Tijit River near the pool called Chizats. Your Lordship, the next line is important. See what the permit says. Besides this area, he is allowed to continue paddy cultivation at the confluence of Tijit and as been shown in the map as. Besides these two areas, he should vacate all the areas he has put under cultivations immediately. Besides this area, he is allowed to cultivate, to continue cultivation.
Yes.
It's very clear, Your Lordship. Permit says permit for farmland, for farming the land. And an area has been given to the petitioner's father for cultivation. And it says, besides that area that is mentioned in the permit, he is allowed to continue at the confluence of Tijit. So the permit says that the area that is mentioned in the permit and the area at the confluence of Tijit, he is allowed for cultivation. Besides these two areas, he should vacate all the areas. This is not an allotment, Your Lordship. This is issued only purely for the purpose of cultivation, Your Lordship. Your Lordship.
Yes.
This cannot be construed into another meaning, my Lord. Of course, by citation, I will support my submission, my Lord. But as far as the special permit is concerned, Your Lordship, this is purely for the purpose of cultivation. It cannot be construed into any other meaning, my Lord. Yes, Your Lordship. Yes, Your Lordship. On one point, I may agree with the petitioner. If at all the petitioner can show that because of this special permit, that land has been allotted to him. In other words, the land has been mutated in his name or in the name of the father by showing a document. Then, Your Lordship, I said the land belongs to him. There are no documents whatsoever.
It was not the allotment. It was probably not mutated.
No, it was never mutated.
It cannot be because it's not. It cannot also be.
Yes.
It was not an allotment. Okay.
Then the question arises. Your
Permission,
Lordship.
so according to you, the permission was not continued
No.
after the death of his father.
Yes, it cannot continue.
But then it automatically, it cannot also goes to the government automatically after his death.
See, my Lord.
The permission. the
See, my Lord.
Formal.
I agree with my Lord. However, the issue is this, Your Lordship. If by basing on this special permit, if his father or the petitioners has approached the government and mutated the land in his name, the government have got no say whatsoever. But it has never been done, Your Lordship. It has never been done. And the very basis of the petitioner approaching this honorable court is this permit alone. There are no other documents showing that the land belongs to him, my Lord. It is only on the basis of this permit the petitioner is here before this court. Your lordship, what transpired thereafter? Your lordship, the incident that has happened, that took place, that is the only thing. But the strength of the petition approaching this honorable court is this, your lordship. In all the averment that he made, your lordship, the petitioner has never said that the land has been allotted to him, or it was allotted in the name of his father. So the land has never been mutated, your lordship. So now, your lordship, now, your lordship, if the land has not been mutated in his name, then, your lordship, who does the land belongs to? So my question now is, your lordship, if I am not the owner of the land, how will I give a special permit itself to a person? Forget about mutation, forget about everything, your lordship. I am allowing a person to do something. That means I am authorized and I am the owner of that land. And that still stand, your lordship, the government is the owner of the land for the fact that the land has never been mutated, your lordship.
No, the thing is that after the death of petitioner's father, the petitioner also continued cultivating, and a government since 1971,
Yes.
because he died long before.
Yes.
So thereafter also government did not take it back. And the petitioner continued cultivating.
Correct.
He was continuing utilizing
Yes. Correct.
the land for
Yes.
his purpose for cultivation, and thereafter he subsequently has also given it to some other person also
Correct.
by way of gift or sale or whatever may be. But he continued possessing the land.
Yes.
That is why he thought that by virtue of his long possession, continuing with
Yes.
the special permit, he is the owner.
Yeah.
And that is why he have done whatever was, of course, as a normal villagers could do, the land under his possession. Because normally what happened is that the land, if you are under possession of the land for over 30, 40 years, automatically it belongs to you. The law also says that.
Your lordship, the only mistake that I admit that the government has committed was after the demise of his father, the allotment or the permit that was given to his father should, by way of a written document, should have cancelled it.
Yes.
Probably that was not done at that point of time. Now it is done.
That having not done,
Yeah.
that is why I'm saying.
Yeah, at that point of time. Now it is done. What has led the government to cancel the permit? That is what my lord may kindly look at it. What transpired the government to cancel the special permit itself, the lordship? And was the government right or wrong in cancelling the permit? Your lordship, kindly see this. Kindly see this. So, your lordship, now it is clear. The land does not belong to the to the petitioner whatsoever by way of any written document. That is clear. That the petitioner cannot dispute it. Yes.
It was cancelled only on 2018.
18.
Okay. Yes.
Yes, my lord. Now, your lordship, what has led to the constitution of the Special Inquiry Committee is this, your lordship. The petitioner has submitted a representation to the chief secretary, to the then chief secretary, in fact, my lord. And the the then Chief Secretary, Your Lordship, has by a letter dated 18th of July 1996, Your Lordship will find it at page 40 of the writ petition, my lord.
Page
Page
40.
40, no, 40, my lord. Yes.
Yes.
Now, Your Lordship, this letter was written to the Deputy Commissioner Mond by the then Chief Secretary in response to the representation submitted by the petitioner. I may be allowed to read this, my lord. Dated 18 of July 1996. A representation has been submitted to me by El Nogman Wanshu, son of late Loktang Wanshu, alleging that illegal encroachment has been taken place in the land given to his father, which he has inherited. This special permit for farmland at Tijit was given to late Loktang Wangshu, the then RCM, and the area given to him was properly delineated. In course of time, encroachment has taken place by the police department, industry department, and also by private individuals through permit given by administration at different time. The land given to late Loktang Wangshu, the then RCM, was in recognition for the assistance he has rendered to the administration and also for standing for the people in terms of difficulty. In fact, without his consent or his successor, no land should have been allotted to any person or government department. It appears that no respect was shown to the permit holder who was given the farmland by the administration in recognition of his service given to the government and the people. Even the Angs of the Tijit areas have consented to this as the land falls within their jurisdiction. The administration should always honor the commitment given by the previous administrations to keep the image in the eye of the people. Instead of protecting the privilege given to certain distinguished person, if the administration allow encroachment by individuals or government department, it does not show any good image before the public. These are the views of the then Chief Secretary. Direction was on the next page, my lord. The direction is, you are hereby asked to conduct special inquiry and submit detailed report. So this was the direction. Plain and simple. A special inquiry report, a special inquiry committee should be constituted and submit detailed report. That was the direction. Now, Your Lordship, this letter of the Chief Secretary dated 18/7/1996 was not complied with by the Deputy Commissioner Mond. And therefore, the petitioner has approached this Honorable Court by filing a writ petition WPC 204K of 2012. Your Lordship will find that at page 50. And the said writ petition WPC 204 K of 2012 was disposed of by the judgment and order dated 5/8/2014. The operative portion, Your Lordship, the direction, Your Lordship will find it at page 52, para 6. Page 52. Para 6. I may be allowed to read para 6, my lord.
Yes.
Although the affidavit in opposition has been filed on behalf of the official respondent, the claim of the writ petitioner has not been disputed. The fact as to issuance of the direction by the Chief Secretary is also not in dispute. This being the position, I feel inclined to allow this writ petition and direct the Deputy Commissioner Mon to hold a special inquiry as was directed by the Chief Secretary by the order dated 18/7/1996 within a period of 3 months from the date of receipt of certified copy of this order without fail, and forward the same to the Chief Secretary for passing necessary orders. The Chief Secretary shall pass necessary orders, final orders within 2 months thereafter from the date of receipt of inquiry report from the Deputy Commissioner Mon. So the same order was passed to the Deputy Commissioner Mon to constitute a special inquiry committee and to submit report. Your Lordship, in compliance to that, in compliance to this judgment and order passed in WPC 204 of 2012 by this Honorable Court, Your Lordship, the Deputy Commissioner Mont has constituted a special inquiry committee which was headed by the ADC Tijit as its chairman. And the same committee has submitted its report to the Deputy Commissioner on dated 31/10/2014. The report, Your Lordship, will find it at page 54. Your Lordship, the first letter, page 54, my lord.
When this order was passed,
Your Lordship, the order was passed on 5/8/2014. And the committee has submitted its report on 31/10/2014.
committee constituted.
Yes, Your Lordship. So this is a letter written by the Additional Deputy Commissioner on dated 31st of October to the Deputy Commissioner with the subject submissions of the Special Inquiry Report. On the next page, Your Lordship will find the report. I may be allowed to read the relevant portion, Your Lordship.
Yes.
The first para, the constitution of the committee, Your Lordship. The Special Inquiry Committee was constituted via letter dated 12/9/2014 in pursuance of the Honorable High Court Kohima Bench Judgment and Order 5/8/2014, WPC 204K of 2012. The Special Inquiry Committee comprised of the following members: 1. ADC Tijit Chairman; 2. SDO's Civil Mont Sardar, Member Secretary; PA to DC Mont, Member; LRSO Mont, Member; Head DB Tijit, Member. So this was the committee members, Your Lordship. The background. In 1971, the then ADC Mon issued a permit to late L. Wanshu as farmland in recognition of his service given to the government and the people via office memo dated 29th of March 1971. In 1974, Sri late L. Wanshu died and the special permit passed on to Sri Wanshu, Nogman Wanshu, the eldest son of L. Wanshu. Sri L. Nogman Wanshu alleged that despite having documentary evidence, the general administration have several times encroached upon his legally inherited farmland by way of issuing permit without his consent. In the same manner, in course of time, government department, including industries, other private individuals, were granted permit by the general administration. As a background of this case, Your Lordship, it is noted that the land of Tijit Township was donated by Jaboka village measuring 1,200 acres The donation was made to the government by the village free of cost without any terms and conditions, which was agreed verbally. These farmlands also fall within the area donated by the Jaboka village. So, Your Lordship, as I have been submitting earlier also, the land, the government owned the land in lieu of the Jaboka village donating the land to the government for establishing the Tijit headquarters. The land was donated to the government for the establishment of the Tijit headquarters, and the special permit that was given to the petitioner's father for cultivation falls within this particular area. It's clear from the report.
Jaboka village donated the land to the government without any condition.
Without any conditions. And it was donated because it was the Tijit for the establishment of the Tijit town. That was the purpose, Your Lordship, for this donation. Now, Your Lordship, how did that 111 notes of permit, which the petitioner is now claiming compensation, came into existence? Is because of a para here. Your Lordship will find that on the last para, allow me to read from page 56, the last para. The second para is about the area only, Your Lordship, which may not be quite relevant, Your Lordship. Yes. On cross-examination of office record on issue of permit, it has been found at various stages and of officers at Tijit, permit was issued by the authority concerned in the name of expansion of town to cater to the ever-increasing needs of the fast populating town government department. Industries and other public utility was set up by the government purely to meet the increasing need of the town. All the above government department utility services are functioning today at Tijit. Next, on the next page, my lord. On physical verification, Your Lordship. On physical verification, it is found that the district administration during tenures of officers has issued 11 notes of permit from 1988 till date.
Okay.
These are not just individual.
Started in the year 1988.
Yes, Your Lordship, these are not just allotment given to the individuals. These are allotment to various government establishment offices there.
No, 111.
Yes. Permit, but not to individuals alone.
Okay, not to individual alone.
Yes, yes. Next para, Your Lordship. During inquiry, it is also found that the complainant Sri Nogman on his own capacity has been selling out plot of land to private individuals at substantial rate without their consent and information to the government. On further inquiry, it was found that a vast tract of land has already been allotted, given free of cost to several private individuals on several locations. It has also been revealed that Sri Nogman, taking full advantage of the privilege given by the government to his father for a farmland, has sold out close to 12 identified individuals by taking substantial amount of money and letter permit acquired by this donee from the ADC office, Tijit. So the issue is, Your Lordship, it is not just that the allotment has been given by the government alone, but that the allotment has also been given to those individuals which the petitioner has sold the land to them. Yes. Then, Your Lordship, the last para.
Yes, some complications are there.
Yes. Then, Your Lordship, the last para. Furthermore, due to this uncompromising stance between the government and Nogman, several individuals taking advantage of the situation.
Where we are?
Your Lordship, at page 57?
Yes.
Yes.
During inquiry.
Third para, yeah. Yeah, during inquiry, I've just read.
Yes.
The next para, Your Lordship. Furthermore, due to this uncompromising stance between government and Nogman, several individuals taking advantage of the situation has been occupying in more than 17 locations plot without any sanction from the government. What has happened to all these things, your lordship? All these individuals who have acquired the land, and what has happened to to those allotment that the government has given? What has happened to them, your lordship? I will show it to my lord at the later stage of my submission, my lord. Committee finding. The special permit issued in 1971, White Memo dated 29th of March 1971, issued by the ADC MON is authentic. However, there is no record of payment of revenue to the government, and the permit does not stipulate any terms and conditions governing the special permit. So no payment whatsoever. It clearly indicates no mutation has been done. So even at the time of the inquiry committee, which held on 2014, it clearly shows that the petitioner is claiming to be the owner on account of the special permit only, my lord. So no revenue given to the government, your lordship. No payment as such has been done. It's very clear. Now, your lordship. Number two. Number two, my lord. It is an accepted fact that the land of Digit headquarter town was donated by the Jaboga village to the government, and the special permit itself was issued to late L. Wanshu by the government. In view of the rapidly growing population of Digit town, the administration need more land for development of the town to appease the growing need of the land for dwelling units. The district administration has issued permit for the purpose of expansion and development of the town. See, your lordship. It was issued permit for the expansion and development of the town. Next page, your lordship, para 3. I may be allowed to read, your lordship. There are already 111 notes of permit issued by the district administration from 1988 till date. Further, 12 notes of plot were settled through the complainant and 17 notes without any permission, adding up to 140 families already settled in the area. Trying to relocate these 140 old families will create a lot of social tension, leading to a grievous and other problems in the town. Number four, the committee was of the view that to bring an immediate and amicable settlement to this issue, an alternative arrangement may be offered to Sri Nokman Wanshu by offering him 200 to 300 square feet of land presently occupied by him, and also in recognition of the service rendered by his father, L. Wanshu, either a school or public hall in the locality be named after him. Last para. Further, during the course of inquiry, the Special Inquiry Committee has received a complaint letter from the village council Jaboka, which are made available to you in original, as the committee has got no legal obligations in reply to this complaint. Your lordship, this complaint letter from the Jaboka village, your lordship, I have annexed it in my affidavit in opposition filed in this writ petition, your lordship. The Lordship will find it at page 24. Yes. Lordship, this is letter dated 25/9/2014, and the letter is addressed to the Additional Deputy Commissioner, Digit Mond.
Yes.
Subject: lodging of complaint against the allotment of special permit for a paddy farm within 1,200 acres of Digit Town to Sri Late Wanshu Konyak. Sir, with reference to the subject indicated above, we, the undersigned of Jaboka Village Councils and signatories, would like to draw your kind attention towards the aforesaid complaint being lodged to your competent authority for your kind redressal, pleased. That, sir, the Jaboka Village has offered donated free of cost a land measuring 1,200 acres for Digit Town development to the government of Nagaland for the well-being of all. However, it is learned that the surplus of land has been occupied and is under the ownership of one individual, Sri Nokman Wanshu, son of late L. Wanshu, with a special permit being issued by the concerned authority. Henceforth, taking this matter very seriously, we strongly condemn and put up an objection against hoarding of land by individuals within this donated land by the Jaboka village. This is for your kind information and necessary action, please. So the Jaboka village also has been expressing their displeasure. As early as 2014, Your Lordship.
Yes.
Now, Your Lordship, there is no dispute to the fact, neither by the government nor by the petitioner, that this plot of land, which is in dispute, falls within the area that has been donated by the Jaboka village. There is no dispute to that. Your Lordship, after the Special Inquiry Committee has submitted its report to the government, the petitioner was not satisfied with this report, and therefore, before issuance of any order basing on the report, Your Lordship, the government and the district administration and the petitioner has held meeting on 2 occasions, Your Lordship. The report of that meeting, Your Lordship, will find it at page 66 of the writ petition, my Lord.
So the government with the petitioner
Yes,
sat together.
yes, Your Lordship.
Page
66, Your Lordship.
So being not satisfied with the inquiry.
Yes,
report,
yes, yes.
The petitioner has also lodged.
Yes, yes. And the district administration and the petitioner has said, Your Lordship, to settle the issue. It is not that, Your Lordship, all of a sudden we issue an order. It is not like that, my Lord. Your Lordship, the report was submitted by the Additional Deputy Commissioner to the Deputy Commissioner on the 2nd of September 2015 at page 66, and the meeting minutes, Your Lordship will find it at page 67. Now, your lordship, report. Allow me to read this report, your lordship.
Yes.
Page 67.
Hmm.
A report of the meeting held with Sri Nokman Wangshu, son of late L. Wangshu, in connection with the special land permit dispute relating to WPC 204, Sri L. Wangshu versus State of Nagaland. Andres. The subdivisional administration, as directed by the Deputy Commissioner Mont, held a meeting with Sri Nokman Wangshu on 10/7/2015 and also on 31/7/2015 in the office chamber of the Additional Deputy Commissioner Tijit with a view to sort out the outstanding issues regarding the allotment of land. During the meeting, certain contention points, demands, and proposals submitted by Sri Nokman was discussed primarily. Point by point discussion are given as under. So these are the demands that he made. 1. Resurvey of special permit as per 1971, but not as per 1975. Resurvey of the special permit has already been carried out on 27/10/2014 with the help of retired Dubashi Sri Achok and Mr. Zenai Konyak, caretaker of Sri Nokman, as these two individuals was present on the spot physically during 1975's resurvey of the 1971 special permit. The areas as per the resurvey done on 27/10/2014 with GPS measures 157.81 acres. Your Lordship, this area is important, 157.81 acres. Since the exact boundary pillars could not be traced as written in the special permit of 1971, the subdivisional administration proposed that the resurvey done in 1975 by Sri Ashok, retired DB, and Mr. Zenai, caretaker, which is again resurveyed on 27/10/2014, along with the above two individuals, to be taken as the actual extent of the area. So 157.81 acres, this is the exact area as per the report. This is accepted facts now, Your Lordship. Number 2, release of compensation from all household already settled by permit issued by administration within the jurisdiction. In the course of development of Tijit town, the need to cater to ever-increasing populations necessitated the administration to issue permit to meet the expansion of the town during various stages of the offices at Tijit. On verification, it is found that the district administration has issued 11 notes of permit from 1988 till date. It is also found that the complainant, also on his own capacity, has been selling allotting plot of land to private individuals without the consent and approval of the government. In this connection, the district administration has received representation from the Tijit Town Public Union, the Jaboka Village Councils, actual landowners, seeking clarifications and complaint against allotment of huge areas of land into a single individuals, as it is a threat to their existence and development activities to Tijit Town in the near future. As such, conceding to this demand will create law and order problems in the Tijit Town. So the demand that was put forward for compensation has already been declined. 3, restorations of all vacant plot area to me filling within the special permit. This is the third demand. I may be allowed to read, my lord. The subdivision administration offered to allot all vacant plot that exists within the survey area down on 27/10/2014 to the complainant, if he agrees to relinquish his claim over the site allotted by the administration. The complainant did not agree to the offer made by this office. Shall I read it again, my lord?
The subdivision.
Offered to allot all vacant plot that exist within the survey area on 27/10/2014 to the complainant, if he agrees to.
Is here.
He is the petitioner.
Okay. If he agrees
To relinquish his claim over the site allotted by the administration. The complainant did not agree to the
what
offer.
does it mean? Site allotted by
The site that has already been allotted by the administration to individuals as well as for the establishment of.
agree to relinquish his
Yes.
claims over the
Yes.
site allotted by the administration. Okay.
Yes,
111.
yes,
Okay, but he did not agree.
he did not agree. Number 4. This is the fourth demand, Your Lordship. To recognize the said area of land as L. Wanshu Colony in memory of my late father. The district administration agreed in principle to forward for recognition and renaming the present industrial colony to L. Wanshu Colony as and when differences are settled. Number 5, to stop issue of fresh permit without my consent prior to 1971 special permit. With the standing order of the Gauhati High Court, those not to issue any permit pata in respects of the petitioner, it was agreed not to issue any fresh permit from both sides until judgment is finalized. The petitioner also verbally agreed to take responsibility for any issue arising out from the sites, plot allotted, sold from his site. Number 6, to stop all double permit holders at present trying to enter within my jurisdiction. This office will look into the matter if such cases arise. Number 7, list of name permit holders issued by district administration within the jurisdiction under special permit from 1971. The list has already been furnished to the applicant, and the list permit allotted from the applicant's side has also been received by this office. 8, it is requested for final settlement of the Honorable High Court case. The case is lying in the court. So the charter of demand, Your Lordship, was also discussed, Your Lordship, with the petitioner. To a certain point, the parties have agreed. To some points, parties did not agree, Your Lordship. Then thereafter, Your Lordship, Your Lord, I would like to take my Lordship to page 78. 78. The petitioner submitted a representation to the Chief Secretary again, Your Lordship.
After that,
Yes.
and this representation was submitted 2019.
However, now, Your Lordship,
Hmm.
the petitioner is now seeking to settle the matter outside the court. And, Your Lordship, if I may be allowed to read the last para only, which Your Lordship will
No,
find it
by
page
by this
17.
representation,
Yes.
by
yes.
this representation,
By
the
this
petitioner
representation.
wants to settle the matter.
Yes,
in
yes,
court.
at page 79.
Okay.
The para that starts with therefore at page 79.
Last.
Yes, therefore.
Yes.
The above para, Your Lordship, are the facts that we have just gone through, Your Lordship.
Hmm.
He is just narrating those facts only, Your Lordship, so I'm
Oh.
not repeating it.
Okay.
Therefore, Your Lordship, it starts with therefore. May I read it, my Lord?
Yes, please.
Therefore, in view of the above facts and circumstances, the undersigned humbly appeals to your august authority to kindly settle the case once and for all in the interest and for the end of justice. Now, Your Lordship, the date is important here. This representation, he submitted it on 5/3/2019. Your Lordship will find that at the bottom part, where he has appended his signature, as well as on the left side of the letter body, Your Lordship.
5/3.
Yes, Your Lordship. This he has submitted it on 5/3. The order cancelling the special permit already took place on 24th of September 2018.
Oh, no, they must have submitted then, after the order, cancellation order only.
Lordship, yes, but nowhere in the
It is not
representation.
mentioned.
Yes, now the petitioner is claiming that he has not received this order dated 24 September 2018. That is a cancellation order. But your lordship will find it that on the next page, the cancellation order. But your lordship may kindly peruse the bottom part of the order, page 80, copy 2. Copy 2. Number 2. Sri Nokman Konyak for information and necessary action. Nokman Konyak is the petitioner here, your lordship. He is claiming, of course, he has made an affirmation in the writ petition itself that he did not receive this. However, the letter has already been, this order has already been addressed to him, your lordship. Now, your lordship could well understand as to whether the petitioner have actually received this or not, your lordship. That I leave it to my lord.
I cannot.
Your lordship.
That you do not know.
Yes. Anyway, your lordship, since the petitioner has submitted this representation again, the government, your lordship, the state government again initiated actions, again took consideration of the representation, your lordship. And a survey was reconducted again because even the state respondent, your lordship, wants to settle the matter. But with a proper verification. And therefore, your lordship, a verification was conducted again, and that verification was submitted by the additional deputy commissioner to the Deputy Commissioner Mount by a letter dated 1st of February 2020. Your lordship, that letter 1st of February 2020, I have annexed it in my affidavit in opposition filed in WPC 58K of 2017. Lordship will find it at page 24.
Report was submitted when? 21st?
1st of February 2020.
1st of February.
2020.
Is it in the writ petition? No.
No, your lordship, it is not there. Therefore, I'll come to all these things, my lord.
Okay, so that letter is not even in your
No.
in your affidavit?
No.
It
No.
is.
They have not annexed it in WPC 88.
Not in 88.
Not in 88.
So it is in?
It is in 58K of 2017.
In affidavit in opposition?
Yes, my lord.
Page
Page 24.
24. So
Before that, your lordship, before that, if I may be allowed to submit one thing. This affidavit, the state respondent has filed it way back in February 2020. The lordship will find that at page 10
is 10
of this affidavit, your lordship. The one that we are having a,
okay, this.
yes, page 10. So we have, yes,
No.
affidavit of 58 K of 2017. The affidavit by the state respondent is respondent number 1.
No, this is. Yes, this is affidavit.
Yes. So we have filed it way back in February 2020. I just wanted to make my lord see the date.
This affidavit was filed on March.
Yes, 2020.
Yes.
Yes, your lordship. So the petitioner is aware of this particular letter.
This particular letter.
That is at page 24.
Page 24.
Yes.
special permit for
Yes.
farm.
Yes.
This is regarding?
This is regarding now the survey, Your Lordship. Am I be allowed to read this?
Yes, please.
See, to the Deputy Commissioner dated 1st of February 2020, to the Deputy Commissioner, Mount Nagaland, subject, special permit for farmland at TG, dated 29/3/1971 to late Wanshu Konyak. Reference WPC 58 of 2017, allotment versus State of Nagaland, others. Sir, in reference to the Home Department, Kohima dated, letter dated such and such dated 27th January 2020, and as directed by the authority, survey was conducted on 31st of January 2020, with the assistance of surveyor, Department of Land Records and Survey, MONT, and the DBs of Digit. Detailed survey report with respect to the land under special permit as sought by the Home Department is provided as per the format requested. 1. Total area as per the survey, 157.81 acres. This is why I was saying that this area is important, Your Lordship. Number 2, allotted to government department offices by ADC Digit.
This is same with the
Yes,
157.
157.
157. Okay.
Yes, this is the same. So the area is, that's why I was mentioning there, Your Lordship, that area 157.81 acres is important.
Yes.
Number 2, allotment to government department offices by the Office of ADC Digit, 0.9280 acres. Allotted to private individuals, organizations by the Office of the ADC Digit, 38.0014 acres. Allotted to private individuals, organizations by the Office of ADC Digit, and plots are presently vacant with no construction carried on it, 4.43 acres. These, the area which are vacant and where 12 permit has been issued by the Office of the ADC Digit. 5. Sold, given to private individuals, organization by Sri L. Nogman Konyak, and permit obtained from the same from the Office of the ADC Digit, 76.912 acres. Sold, given to private individuals, organization by Sri L. Nogman Konyak, with no permit obtained from the Office of ADC Digit, 17.548 acres. Sri L. Nogman Wanshu residence and his fishery pond measuring 0.067 acres is also within this area. 7. Sold, given to private individuals by Sri Nogman Konyak and permit taken, but the plots are presently vacant with no construction carried on it near. 8. Sold, given to private individuals by Sri Nogman Konyak and no permit taken, and the plot are presently vacant with no construction carried out on it, 0.2295 acres. Plot occupied by private individuals, organizations, and not sold given by Sri L. Nogman Konyak, and permit also not given by the Office of ADC Digit, 0.5171 acres.
So these are illegal occupant.
These are illegal occupant. Vacant plot and not sold given by Sri L. Nogman Konyak and not permit and no permit given by the Office of ADC Digit, 7.674 acres. Circular road and drainage, 16 acres. Next, Your Lordship. The total area claimed by Sri L. Wanshu Konyak to arrive out of court settlement, Your Lordship, see, is 5.1 acres out of 4.43 acres, out of which 4.43 acres is presently vacant with no construction, and 12 permit has been issued by the Office of the ADC Digit, and the remaining 0.67 acres is his residence and the fishery pond. The survey report is therefore submitted for your kind information and further necessary action, please. Background. I wanted to point out one thing here.
This report was submitted by the ADC.
ADC.
Based on the direction of Chief Secretary direction.
Yeah,
No, not direction.
by the government. Direction on the
Based
direction
on
of
the
Home Department.
representation submitted by.
By the government. Direction given by the government, the survey was conducted.
Okay.
Your Lordship,
Yes.
I wanted to take my lordship to the point number 5 at page 24.
Point number 5.
Yeah. Sold or given to private individuals, organization. Sold or given to private individuals, organization by Sri L. Nogman and permits obtained from the same from the office of the ADCTG. So permit was also issued to those individuals who have purchased it from the petitioner. Allotment has been, the permit has been given to them. You see, Your Lordship, its area is 76.912 acres.
Okay.
Next, Your Lordship. 6. Sold, given to private individuals, organization by Sri L. Nogman Konyak, and no permit obtained from the office of the ADCTG. 17.548 acres. So if two areas are calculated together, it comes to 94.0195 acres. 94.0195 acres. This figure is important, Your Lordship. These are the areas where which the petitioner has sold it, Your Lordship. Page 26, Your Lordship.
Yes.
Your Lordship. This is the background. This is the background of the area. Your Lordship, we are going back to the same. This is how I will start with para 3. In the year 1971. I'll start from that para.
I think
Oh, Your Lordship.
we have to continue at 2.
Lordship.
What is time now?
Your Lordship, yes, it is 1.
I think that what?
Yeah, it's
that clock.
Oh, you died, I mean, it's not better.
If we wait for that clock, then
Yes.
we'll
You would have taken advantage of it. Lordship, at 2.
So
Since my argument has been completed long back, Lordship, as far as I'm for the newly related, the Japawa village, I've already made my stand.
okay.
My stand is that like we donated the land. So if the government is not going to utilize the land judiciously, we have to take back our land, Lordship. That is the only issue with us.
Okay.
Family.
Okay. We'll continue. Yes.
Very please. Lordship, I was in page 24. I was in page 24 of the
Yes.
affidavit.
26. Page 24
Yes.
of the affidavit.
Yes, Your Lordship. Affidavit of 58 of 2017.
Yes.
So I've shown my lord point number 5 and 6 and the area.
Yes.
Now I'd like to take my lordship to page 26.
Yes.
This is the background, Your Lordship.
So this background
Yes.
is the part of the inquiry report.
Yes, this is a part of the inquiry report.
Okay.
Now the first 1-2 para, Your Lordship, is about the facts and the area, how it is bounded. So I will not go into that. Your Lordship, I will start with para number 3, that is starting from in the year 1971. I may be allowed to read this out.
Yes, please.
In the year 1971, the then ADC MON has issued a special permit dated 29th of March 1971 for farmland to late L. Wanshu RCM within the 1,200 acres of land, which was denoted free of cost for Tijit Township by the Jaboka village to the government. Initially, Your Lordship, the area was thick forest where human habitation was not expected in view of the land condition. The then ADC might have issued a special permit for farming only so that the jungle can be cleared for human settlement. Likewise, late L. Wanshu has cleared off the jungles and developed the land by way of banana plantations and sugarcane plantations. In the year 1975, there was an encroachment upon the farmland by Sri Nokzan, chief of Ang of Jaboka, and late Timpong Dibi. The then CO Tijit Sri Imkong Jamir has stopped the encroachment since late Wanshu was developing the land by cultivating sugarcane, banana, etc. Your Lordship, as the year progressed, many government department was established in the Tijit headquarters, which led to urbanization, as a result of which villagers migrated from neighboring village to the present headquarters. Due to rapid urbanization, Sri L. Nogman Wanshu, eldest son of late L. Wanshu Konya, started to sell out acres of land by virtue of special permit issued to his father to individuals without the knowledge and permissions from the government. At the same time, due to increasing need for public utility services, the office of the ATC Tijit has also issued permit to the government departments and individuals within the boundaries of the special permit issued by late L. Wanshu in 1971. Being aggrieved, Sri L. Wanshu made a representation before the Chief Secretary Nagaland, who issued direction to DC Mon by order dated 18/7/1996 to hold special inquiry and submit report at the earliest. The special inquiry report asks did not materialize for 18 years' time. However, on 12/9/2014, a special inquiry committee was constituted by DC Mon to verify the case. The special inquiry committee has successfully conducted the verification and placed its report to the government. During the conduct of the inquiry, various complaints against Sri L. Nogman was received by this office. Present status. Your Lordship, before that, as I was submitting, the issue of giving allotment was not only to the individuals, but also to various government offices for its establishment at Tijit. This particular para supports what I have been submitting, Your Lordship, as it is clearly stated. Your Lordship, present status. On 27th of January 2020, the Home Department directed the Office of the ADC Tijit to submit details of the land by letter dated such and such. According to the survey was conducted, and the following are the details. 1. Total land as per survey, 157.81 acres. Area allotted by the Office of the ADC Tijit, 38.0014 acres. Area of land sold or gifted by Sri L. Nogman, 76.912 acres. So I'll come to 111 notes of permit, Your Lordship, at the end of my submission. But here, from this itself, it is very clear that it is the petitioner who actually sold land or gifted to individuals more than the allotment of the government itself. Very clear, Your Lordship. If we see 111 notes, Your Lordship, it appears that the government has substantially, allotted portions of those lands to private individuals. It appears like that. But look at the area from this report. Then, Your Lordship, the order on the next page.
Yes.
Your Lordship, this I wanted to also point out one thing here, Your Lordship. Here, the area that has been mentioned in the present status as 76.912 acres. These are the areas where the petitioner have sold it to private individuals and permit has been obtained from the ADC Digit. Your Lordship will find that at point number 5. That is why I was reading this over and over again, Your Lordship. The next area, which he has given it, but no permit has been obtained from the ADC office, has not been mentioned in the present status. It is only that area where he has sold it to the private individuals and where permit has been obtained from the ADC Digit. That is the allotment permit. What permit means?
What permit?
Allotment. Allotment taken from the ADC office, but the land sold by the petitioner. This is the area mentioned here. 76.912 is comprised only of those areas which the petitioner has sold it to the private individuals, and those individuals has taken land allotment permit from the ADC office. Your Lordship. Now, Your Lordship, allow me to take my Lordship to page 81 of the writ petition 88.
Page 81 of?
Writ petition 88.
Hmm.
This is a letter written by the Home Commission to the Deputy Commissioner on dated 25th of January 2020. Now, this letter is impugned, Your Lordship. This letter is impugned in the writ petition 88. Allow me to read this, my Lord. Government of Nagaland, Home Department, General Administration, Branch 1, dated 25th January 2020, to the Deputy Commissioner, Mount Nagaland, subject, regarding special permit for farmland at Digit, dated 29/3/1971 to late Sri Wanshu Konak. Sir, please refer to the subject cited above and the letter number, dated 1st of February 2020, from the ADC Digit addressed to you with regards to the status of the entire land under the special permit as is existed on date. And another letter dated 8th of January 2020 from ADC Digit addressed to you, mentioning the meetings with Sri L. Nokman Wanshu for settlement of the entire dispute concerning the aforesaid land. I wanted to point out one thing here, Your Lordship. From this first para itself, it says, please refer to the subject cited and the letter number JUDL/LR-1/2019-20, dated 1st of February 2020. So this letter is referring to a letter dated 1st of February 2020. And what is the letter 1st of February 2020, Your Lordship? Is the survey report that I've just referred to.
Report.
Yes. As I proceed further, your lordship will get it clear. So in other words, your lordship, what I'm trying to say is that this letter dated 25 January 2020, which we are reading right now, has been born from the letter 1st of February 2020. I may be allowed to proceed, your lordship. The detailed report of ADC digit of the land under the special permit shows that out of 157.81 acres of land, initially, Sri L. Nogman Konyak has over the decades sold or given 94.10195 acres of land to various individuals, organizations, which is about 60% of the total land. The area of the land which is allotted to private individuals, organizations by the Office of ADC Digit is 42.4314 acres. The land utilized by for government department offices and for roads and public utility service like drain is about 16.926 acres. The report also mentioned that after survey, the land under actual possessions of Sri L. Nogman Wanshu Konyak, his residence and fishery pond is 0.67 acres and not 5.1 acres as reported earlier. The report states that the vacant land behind the house of Sri Nogman Wanshu Konyak, which was allotted to 12 private individuals by ADC Digit in 2012, and which has been asked now by Sri L. Nogman Wanshu for settlement, covers an areas of 4.43 acres. Now the question is, your lordship, from where in this letter the area 94.0195 acres comes? Allow me to take back to the survey report that was submitted on 1st of February 2020, your lordship. Your lordship may kindly refer point 5 and 6. And this is why I was being saying earlier, this area is important. Point 5. Your lordship, sold given to private individuals, organization by Sri L. Nogman Konyak, and permits obtained for the same from the office of the ADC Digit is 76.912 acres. Number 6, sold given to private individuals, organization by Sri L. Nogman Konyak, and no permit obtained from the office of the ADC Digit, 17.548 acres. If these two are add up together, it comes to 94.0195 acres. This is what is mentioned in the impugned letter. Now, your lordship,
Yes.
yes, your lordship. So 94.0195 acres come from these two portions of land, your lordship. Now, Your Lordship, again, an area of 42.314 acres is also mentioned. Wherein it is said that the area of land which is allotted to private individuals organization by the office of the ADC Digit is 42.4314 acres. This, Your Lordship, is the area which is mentioned in point number 2, point number 3, and point number 4. That is allotted to private individuals organization by the office of the ADC Digit 38.0014 acres and allotted to private individual organization by the office of the ADC Digit and the plot are presently vacant with no construction carried out 4.43 acres. These two combined together and the area comes to 42.4314 acres.
So by this letter, what the Home Secretary want to convey to Deputy Commissioner?
No, it has been conveyed, Your Lordship. Allow me to go through.
Okay, yes.
Yes. So, Your Lordship, number 3. It is thus clear that Sri L. Nogman Wanshu Konak has over the years already disposed of substantial portion of the land under the special permit, which was given to his father for cultivation purpose only, by giving, selling to many private individuals, organizations without any intimation or consent of the government. Hence, it will not be proper to consider allotting any more land to L. Nogman Konyak. The ADC Digit may accordingly be asked to convey the same to Sri L. Nogman. Your Lordship, this para is mentioned for the fact that the petitioner, in order to settle out of court settlement, is asking for 4.43 acres, which is mentioned at point number 4 in the survey report. Now, these are the vacant land. And in order to come to a settlement, Your Lordship, the petitioner is seeking this area, 4.43 acres. That is what this para has been. It has been explained as to how no more land area should be allotted to the petitioner. In the first para itself, Your Lordship, it is clearly mentioned on the last line, which has been now asked by Sri L. Nogman Wanshu Konak for settlement covers an area of 4.43 acres. First para, the last line. This is the area he's demanding.
Now, it says that 4.43 acres
Yes.
is being asked by the petitioner
Yes.
from the government
Yes, from the government.
to allot him.
Yes, for settlement.
So, what is the then opinion of the government?
Don't decline.
So this 4.43 acres of land is
Yes.
still under his possession? or
No. It is not under his possession. Your
This is a vacant land then?
This area was allotted to 12 individuals.
Okay, 4.43.
Yes, Your Lordship. It has been allotted to 12 individuals, which the government has subsequently cancelled.
Why it was cancelled?
Your Lordship, the allotment has been cancelled by the government.
Okay, but after cancellation, it is vacant land now?
It is vacant land now, Your Lordship. It belongs to the government again.
Now the petitioner is claiming this.
Yeah, for settlement.
So what is the opinion of the government? Government
The
declined.
Barak 2, Your Lordship. By Barak 3, the government has declined to give him. because he has sold substantial portion of the land
Hmm.
amounting to 94
Okay,
point
what
zero.
about then the status of the land which was given by the petitioner to the other individuals? And then some of the, some portions out of that 76 was allotted by the government also.
Yes,
Subsequently, they obtained, so the government is not disturbing them.
the government have started cancelling those allotment also.
Those also.
Yes, your lordship.
And then about 17, this 17, in which given by the petitioner to the individuals which was not granted or given any allotment by the government. What about that?
That, your lordship, that area.
They are also, these 17
Yes.
acres is
yes.
under the possession of the individual persons.
No, your lordship, the government have started cancelling those allotment itself, your lordship.
No, those
Not
were not
that.
those were not the allotted one.
Yes.
Allotted one is 76 only.
Chief, let us proceed further. It's
Yes,
mentioned here.
yes,
Let us
yes.
proceed further, your lordship. Para 4. Everything is mentioned here, your lordship. Para 4.
Okay. Mm.
As recommended in the Special Inquiry Report 2014 by a committee headed by ATC TG, you may make allotment to Sri L. Nogman Konyak only for the land measuring 0.67 acres, which is under his actual possession. So his actual possession is 0.67 acres, your lordship. I was trying to point this. Further, as also recommended in recognition of the service rendered by the late father, Sri L. Nogman Konyak ATC TG, may be asked to take concrete steps in the directions of getting a school or public hall in the locality named after Sri L. Wanshu Konyak. This is one of his demands. I've shown it, I've read it. This is what he has demanded, your lordship, in the meeting held with the district administration, which I've already read it out. Shall I continue, my lord?
Yes, please.
Number 5, further in public interest and taking into account the present circumstances as it exists in the TG town, all the vacant plots, tract of land falling under the special permit need to be kept for use by any government officers or for taking up any development activities that may come up in future. Hence, you may take immediate steps for cancelling the allotment covering an area of 4.43 acres to 12 private individuals made by ATC TG in the year 2012, which is a consolidated tract of land at one place and mentioned as serial number 4 in the ATC TG report dated 1st of February 2020 and take under the custody of the government. Allotment has been asked to cancel. That's why I said 12 private individuals, your lordship. It has been done, cancelled. Number 6, the vacant plot not sold or given to the private individuals by Sri L. Nogman Wanshu Konyak or allotted through any permit by ATC TG, as well as those plots sold given to the private individuals by Sri L. Nogman Wanshu but vacant, mentioned as serial number 10 and 8 in the report of ATC TG, which measures 7.674 acres plus 0.2295 acres, that is amounting to 7.9035 acres, may also be taken over by the government. In all these cases, proper allotment orders in a manner as considered appropriate by you may be made so that there's an absolute clarity that those tracts of lands belong to the government. So that answers my lordship's question as to what happened.
So government want to keep it,
Yes,
the government.
your lordship.
Mm.
Your lordship. Number 7. As regard the land already allotted to private individuals by Sri L. Nogman Wanshu, and which are not vacant, with some construction done or some development of the land done in some manner, and for which permit have been given by ATC TG, as mentioned in serial number 6 of the detailed report from ATC TG. You may prepare a proposal and submit to this office for regularizing such allotment by getting permits issued by ATC TG. Action on similar lines may also be taken for an area of land 0.517 acres, which is not vacant, and over the years have got occupied by private individuals, organizations without allotted by ATC Tijit or being sold by Sri L. Nogman Wanshu as mentioned as serial number 1 of the report dated 1st of February 2020. You may take immediate steps for taking action on all points. Lordship, every detail, every part of the land has been touched. Every part of the land that has been mentioned in this report has been touched.
This refer to which report? Report.
1st of February 2020, everywhere in the bracket is mentioned.
It has. Okay, that much of serial.
First of February 2020.
Okay. So after this report, this is a direction.
Yes. After this report, this is the text. So now.
Yes.
So now, Your Lordship, this report
Hmm. Okay, yes.
Now, Your Lordship, as Your Lordship was inquiring,
Hmm.
the possession by the petitioner. Possession by the petitioner is, Your Lordship, 0.67 acres. This is his real possession.
0.67 acre.
Yes, this is his real possession. And this possession that is being held by him, Your Lordship, we have allotted this to the petitioner.
This already allotted.
Yes,
When this was allotted?
Your Lordship, it was allotted on 25th of February 2020. Your Lordship will find it on page 28
Of the?
of the affidavit in opposition filed in WPC 58K of 2017.
Hmm.
I may be allowed to read this, my lord.
27. Page 27.
Page 28.
Page 28.
28.
Okay.
Government of Nagaland, Office of the Additional Deputy Commissioner Tijit Mon Nagaland, order dated 25th of February 2020. With reference to the Home Department letter number such and such dated 25th of February 2020. Kohima, in respect of this special permit for farmland at Tijit, dated 29th of March 1971 to late Sri Wanshu Konyak, a plot of land measuring 0.067 acres, bounded by the schedule of boundary as mentioned below. North, MK John Fishery Pond, east, government school, government land, west, approach road, south, Shipa Konyak, is hereby allotted to Sri L. Nogman Wanshu Konyak. So the land, Your Lordship, the question that has been put forward by this honorable court is the possession of the land. What has happened? That possession of the land has already been allotted, Your Lordship.
Hmm.
The other portion of the land,
Hmm.
the other portion of the land, which comes to 157.81 acres out of the total area. The other portion of the land, as seen from this report, Your Lordship, is never in the possession of the petitioner. You see, Your Lordship, the report. Page 24.
So now this total, as per the report,
Yes.
from serial number 1 to, sorry, 2, the total area is 157.81.
Yes.
And then the division here comes, how much it comes total?
It comes to that area, Your Lordship.
Exactly 157?
Yes.
Okay.
Well, besides, of course, eliminating that area which has been given to the petitioner, Your Lordship.
Including the area which has been given
Yes,
to the
yes, yes.
petitioner.
That comes to 157. This is not disputed area.
So this is the detail of the area,
Correct,
division of the
Correct.
area.
correct,
Okay.
correct. And see, Your Lordship, is the petitioner in possession of any of the land, Your Lordship, besides that 0.01,
The
0.067?
petitioner land comes under which one? Sorry, and is fish point, okay, 0.67.
Ha,
This is under 6,
yes, under
serial number
6.
6.
Under 6. The rest of the area, it has been sold. Allotment has been given.
Okay, the total lane, vacant lane is now 7.674.
Yes,
It appears, serial number 10.
serial number 10.
So this is, no allotment was given.
No, Your Lordship, the government have taken a decision on this also.
What decision?
Your Lordship, I'll show it to you, my lord. Kindly read para 6, Your Lordship. Allow me to read. Para 6. Para 6 of the impugned letter.
Okay,
Para 6.
yes.
The vacant plot not sold, given to private individuals by Sri L. Nogman Wanshu Konyak or allotted through any permit by APC Tijit, as well as those plots sold, given to private individuals by Sri L. Nogman Wanshu but vacant, mentioned as serial number 10 and 8 in the report of ADC Tijit, which measures this 7.9039 acres may also be taken over by the government.
Okay, only says this may also be taken over by.
By the government.
So this actually was assumed that it was still under the possession of the petitioner.
No, Your Lordship.
Yeah, which comes under the farmland. Otherwise, it comes under the farmland only. farmland,
Comes under farmland. Comes under farmland.
comes under the
Yes,
special
yes,
permission.
yes. But the actual possession of the land is there only, Your Lordship.
No discussion. Okay, no discussion. Hmm. So the principal secretary wanted to ensure that all the rest of the land
Ah,
should come under the possession of the
Correct.
government.
correct. Now, Your Lordship,
Hmm.
the issue is this. The impugn of letter is born out of the report.
This
Of,
letter,
of this report.
report is not under challenge.
Report is not under challenge.
Okay, this.
Yes. So the impugn order comes from this. The impugn order actually is born out of this report, Your Lordship. So the impugn order becomes the consequential order and the report becomes the basic order, Your Lordship.
Hmm. So
So without challenging the basic order, Your Lordship, the petitioner any person challenge the consequential order. That is another issue, Your Lordship, that need to be decided. Your Lordship, see, why I was asking my Lord to see when did we file this particular affidavit?
so it was under under their knowledge.
Yes, it was under his possession, Your Lordship. Not only that, Your Lordship, not only that. We have filed it in February 2020. WPC 88 impugning this letter, Your Lordship, was filed on Lordship, may kindly see 19/5/2022.
Okay. Just a minute.
Your Lordship. So the basic order has not been challenged as far as this impugned letter is concerned, Your Lordship. What has also been impugned, Your Lordship? Kindly see. Kindly see, Your Lordship. What has also been impugned? Your Lordship. Another impugned order, another order that has been impugned is the cancellation order. Is the cancellation order. Cancellation of the special permit order dated 24th of September 2018.
That has been impugned.
Yes, that has also been impugned. Allow me to read, Your Lordship. Page 80. Page 80.
Page 80.
80.
Yes.
Allow me to read.
Yes.
Order dated 24th of September 2018. In pursuance, Your Lordship, see, in pursuance to the letter from the Home Department, Government of Nagaland, by letter number GAB 14 code /167/2017, dated Kohima, the 14th of September 2017, with regards to the special inquiry report on the special permit issued to late L. Wanshu Konyak for farmland at Tijit headquarters. The permit number such and such dated Mon 29/3/1971 is hereby cancelled with immediate effect in view of the expansion and development of Tijit administration headquarters, requiring all vacant land for the public office establishment. So this order was issued in view of the letter dated 14 September 2017. What is this letter, Your Lordship? Again, Your Lordship, allow me to take to the same affidavit, 50.
Yes.
Your Lordship. So, what is this letter? Your Lordship will find it at page 22 of my affidavit filing, WPC 58, page 22.
Yes.
I may be allowed to read.
Yes.
Government of Nagaland, Department of Home, General Administrative, Branch 1. Letter dated 14 September 2017. Number, Your Lordship. Number GAB 14 code 167/2017. Number, letter number, and date. To the Principal Secretary and Commissioner, Nagaland, subject special inquiry report on special permit to late Wanshu Konyak at Tijit headquarters. Sir, the government has perused the report of the special inquiry report on the above subject site submitted by letter number such and such dated 10/12/2014 and convey the decision taken as under. Convey the decision, Your Lordship. 1. The special permit issued by number 8487-90 dated Mon 29/3/1971 to late L. Wanshu for farmland at Tijit may be cancelled with immediate effect in view of the expansion and development of Tijit administrative headquarters, requiring all vacant land for public office establishment. Number 2, regarding physical occupation by way of permanent structures by Sri Nokmant Konyak, son of late Sri Wanshu Konyak, physical verification may be made by DC Mon, after which proper land allotment for permanent possession of the land may be made. Therefore, necessary direction may be issued to Deputy Commissioner Mon for implementation of that part. This order, which has been impugned, is again born from this letter dated 14/7/2017. This impugned order is again the subsequential order of this letter. Here there are two decisions taken, Your Lordship.
It was only person to this letter.
Yes,
The special permit was cancelled.
yes. So the cancellation of the special permit by order dated 24 September 2018 is the consequential order of this particular order dated 14 September 2017, which is not under challenge again, Your Lordship.
Yes.
So, Your Lordship,
Hmm.
now the question of law is whether a consequential order can be challenged and sustained before this honorable court without challenging the basic order. And the answer is simple, no, Your Lordship. I can place citations on this, but since Your Lordship is well aware of it, Your Lordship, I will not place any citations. Otherwise, the law is very clear on this, Your Lordship. Without challenging the basic order, consequential orders cannot be challenged. And this basic order was before him, Your Lordship. Even before the consequential orders was impugned by filing a writ petition. It was before him.
Hmm.
He chooses not to challenge, Your Lordship. Therefore, Your Lordship, now, the first prayer of the petition is gone, Your Lordship. That leaves us only with prayer number 2. And what is the second prayer, Your Lordship? Kindly come to page 26, Your Lordship. As far as Your Lordship, prayer number 1 is concerned, Your Lordship, I would not like to make any further submission. Yes, Your Lordship has already got it. Prayer number 2. Your Lordship, may kindly come to page 26.
Yes.
Page 26, Your Lordship. Prayer number 2. Direct the petitioner, the said respondent to pay land compensation to the petitioner for the area covered by 1 notice of permit issued to the settlers on the petitioner's land, and further direct the said respondent not to encroach any further and desist from issuing any more allotment permits against the land encompassed by the special permit 29/3/1971. Your Lordship, at the beginning of my submission, I have stated categorically make a mention that compensation can be paid to a person who can show that he is the landowner. Compensation cannot be made just because a petition or a person claims that the land belongs to him. He has to prove it. He has to prove it that the land belongs to him, Your Lordship. Now, Your Lordship. So as I was saying, Your Lordship, compensation cannot be made to any person just because he is claiming to be a landowner. He has to prove it. When he comes before this honorable court, Your Lordship, claiming certain things, he has to first prove it. There is no document, Your Lordship, except the special permit. It shows that the land has been mutated in his name, or, Your Lordship, he has inherited it in lieu of the mutation done in the name of his father. No document. Therefore, I said, Your Lordship, from the beginning, the petitioner is here before this honorable court only on the strength of that special permit, nothing more. Now, Your Lordship, the irony of all this is the 111 number of permit, Your Lordship, that was issued, which is mentioned in the special inquiry report, Your Lordship, has not elaborated whatsoever that 111 number of permit was issued by the government alone, not on account of the petitioner selling the plot of land and those individuals approaching the government for issuing of that allotment order to them. Nothing is mentioned. But from the report submitted on 21st of February 2020, it is clearly visible that 111 of no permit that was issued also was for those plot of land which has been sold by the petition, and those people approached the district administration for land alone. Now, Your Lordship, a person sold a land and the permit was obtained, or the allotment order was obtained from the district administration. Should the government again pay compensation for that land that he sold it? Just see, Your Lordship. A good portion of land has been sold by the petitioner, which is here in the report, and he has not disputed this. Meaning thereby he has accepted it. It was before him. It was before him, Your Lordship. He has not disputed this at all.
this, what you are saying, permit is an allotment, actually.
No, no.
No. Permit given to the private.
No,
No, you say that the petitioner has given or sold land to some private individuals.
yes.
These private individuals approach the authority and authority has issued
Allotment order to them.
allotment order. It's
Yeah.
not, okay.
And for those portions of the land that he sold it also, your lordship, he is seeking compensation. Is that permissible, your lordship? Look at the report. 76.9912 acres has been sold, and those individuals has come and obtained this particular allotment order from the district administration. After selling off at an exorbitant rate, your lordship. That also without any document showing that the land belongs to him. Look, the petition is here before this court seeking compensation on those 8 lands also that has been sold by him, your lordship. Is that permissible? Now, your lordship, that leaves us with only one question. That is this land belongs to the petitioner? Or how is the petitioner claiming that this land belongs to him? Is it not on the basis of the special permit, my lord? And your lordship, the petitioner has been submitting that the special permit for farmland was issued by the district administration to his father as a gift in lieu of the service that he has rendered.
Yes,
It is as a gift. That is what the petitioner has been contending.
yes.
Now, your lordship, not only contending, in fact, he has written that also, your lordship. Allow me to take my lordship to page 84. This is another representation after all these things has happened. He has submitted another representation to the Home Commission. Page 84.
Yes.
Page 84. To the Home Commissioner, am I allowed to read, man? To the Home Commissioner, Nagaland, subject, renegotiation of land dispute under special permit issued to the petitioner's father on 29/3/1970. So he wanted to renegotiate now, your lordship. Reference is such, your lordship, sir, with due respect, the undersigned hereby brings you a kind notice that this is the second time that the applicant petitioner is approaching your competent authority for settlement of land dispute in respects of the special permit which was given to my father on 29/3/1971 by this administration in recognition of his service rendered to the government and its people during difficult time. 1. On earlier occasion, I have approached your authority concerned by my publications dated 5/3/2019 for settlement. However, in the meantime, while the same was under process to the utter shock, an order dated 24/9/2018 was served upon me sometime in the month of April 2019, whereby the special permit dated 29/3/1971 was cancelled without issuing show cause notice, and more surprisingly, when the matter is pending before the honorable court, which clearly exhibit the ulterior motive of the responding authorities and thereby undermine all the tenets of justice. Despite of which, applicant petitioners in good faith participated in the settlement process, expecting that some positive outcome will emerge through the settlement. However, the responding authorities taking undue advantage of their chairs of office usurped all the petitioner's legitimate right over the special permit which was gifted, Your Lordship, see, which was gifted to his father by the district administration in recognition of his immense contribution towards government and its people during difficult times and trying times. Therefore, to ascertain the clear pictures of the case, it is expedient to analyze hereby the special permit as follows. So, the petitioner is now claiming, Your Lordship, that the special permit is a gift. Is a gift to his father. Your Lordship, come to para 2. Para 2. Please come to para 2, Your Lordship. Special permit dated 29/3/1971 was given to the petitioner's father as gift by the administration in recognition of his service to the government and his people during difficult times. So the petitioner now is claiming that this particular special permit is a gift. It's a gift, Your Lordship. Your Lordship, allow me. Allow me to take my Lordship to Transfer of Property Act 1882. Section 1 to 2. Section 122, man.
Yes.
I may be allowed to read.
Mm.
Gift, definition.
Mm.
Gift is a transfer of certain existing movable or immovable property made voluntarily and without consideration by one person called the donor to another person called the donee and accepted by or on behalf of the donee. Section 123. Transferred, how affected, Your Lordship? This is important. For the purpose of making a gift of immovable property, the transfer must be effected by a registered instrument signed by or on behalf of the donor and attested by at least 2 witnesses. Your Lordship, allow me to take. Allow me to take to the special permit, Your Lordship.
Mm.
Page 32. This is the special permit, Your Lordship.
Yes. Mm.
Lordship, what was the transfer? How can the transfer be effected? It says a gift of immovable property, the transfer must be effected by a registered instrument. Where is the registered instrument here? Where has it been registered, the Lordship? Not only that, it is signed by on behalf of the donor and attested by at least 2 witnesses. Where is the witness, man? Where is the witness here?
Mm.
Let us read further, Your Lordship, on the next paragraph of section 123.
Yes.
It says, for the purpose of making a gift of immovable property, the transfer may be effected by a registered instrument signed as aforesaid by the deliverer. Where is that registered document, Your Lordship?
Or by delivery.
Yes, or by delivery.
It was delivered.
No, signed as above, Your Lordship. Signed as aforesaid. There is aforesaid paragraph.
Mm.
Where is that affected registered instrument document. Where is it registered, my lord? So on what basis, your lordship, the petitioner is claiming to be an owner of the land? He said it's a gift deed. For once, let us admit it is a gift deed. Does it comply with the gift deed that's been mentioned in the act, your lordship? No. This is just a mere document, your lordship, nothing more.
Okay,
Your lordship, nothing more.
yes.
Now, your lordship, if it is not a gift deed, how is the petitioner claiming to be an owner of the land? Because, your lordship, see, the only basis, as I have been stating, is on the basis of this particular fund, a special permit. To make it more clear, your lordship, to make it more clear,
Yeah,
your lordship, for my understanding only, your
Yes,
lordship,
yes, yes.
for my understanding only,
Hmm.
what is a permit? Allow me to refer to Oxford Dictionary, your lordship.
permit.
Permit. It says, give consent to, authorize. I have my lordship got it. Permit.
Yes,
May I read it, my lord?
yes.
Give consent, permit, give consent to, authorize, allow, give opportunity, allow as possible, written under order, giving permission or allowing entry. It is just allowing to do something, your lordship. Nothing more. And therefore, what does the permit say? Allow to cultivation.
Permit. Officially allow someone to do something.
To do something, see, your lordship, just to do something. And what is the thing here in our case, your lordship? For cultivation. Nothing more, your lordship. It is not a declaration of titleship or ownership, your lordship. Permit is not a declaration of ownership. Neither is a declaration of titleship, your lordship.
Hmm.
So the meaning of permit is very clear, your lordship. It's allowing somebody to do something or authorizing a person to do something for which the permit is given, your lordship. Nothing
Yeah.
more than that. Now, your lordship, what does the apex court says when a document is placed before the honorable court? How should the honorable court interpret it?
1 minute. Huh?
Allow me to place
Call.
a place citation. 2024 7 SSC. Your
Hmm.
lordship, 2245.
We'll take break for 2 minutes.
Lordship.
Hmm. What is this?
This is about interpretation of deed by a high court. What does the apex court say?
Interpretation of
Deed.
deed.
Yeah, deed. D-W-E-D. Lordship, I would like to refer to para 21. Para 21.
Yes,
Para 21. Your Lordship, it starts with, it is well settled, Your Lordship.
yes.
It is well settled. Allow me to read, Your Lordship. It is well settled principle of interpretation that in the interpretation of a deed, the question is not what the parties to the deed may have intended to do by entering into that deed, but what is the meaning of the word used in the deed. The court can understand the true intent of the deed only by the words used in the deed. It does not matter what the parties in their most state of mind thought what the terms meant. They may have meant different things, but still the terms or the language used in the deed should bind them. It is for the court to interpret such terms or language used in the deed. See, Your Lordship. And what is the language used in the deed, Your Lordship? In the permit. For cultivation purpose. So the parties may have their own interpretation and their, may have their own thoughts. But it should be decided on the terms of the language used in the deed. Para 22. In Ram Gopal versus Nandla, it is held that in construing a document, the fundamental rule is to ascertain the intention from the words of the deed. The surrounding circumstances are to be considered, but that is only for the purpose of finding out the meaning of the words which has been actually employed in the deed. It would apposite to refer to the following para. In construing a document, Your Lordship, whether in English or in vernacular, the fundamental rule is to ascertain the intention from the words used. The surrounding circumstances are to be considered, but that is only for the purpose of finding out the intended meaning of the words which has actually been there. See, Your Lordship. What is the word used here, Your Lordship? What is the word used here in the special permit? The permit is granted for a particular purpose, that is for cultivation only. It cannot be interpreted in any other way. Even if it is interpreted, Your Lordship, the word that is being used here has to be taken into consideration by deciding the matter. That is, it is very clear from this judgment, Your Lordship.
So that means had the petitioner continue cultivating without, of course, giving any part of land to anybody, any individual persons, then it will continue. That means,
Your Lordship, that
but then without canceling or without canceling that permission also, you have started giving allotment to the individuals.
Your Lordship, I have started allotting the land to the private individuals, also on those portions of the land which the petitioner sold.
That is true. That is true. That probably they will have to explain because they have not challenged that also.
They have not challenged. And then, Your Lordship, those are not the issues. The issue is how is this land belongs to the petitioner? How is this land, Your Lordship? I said yes, 0.67 acres which has been allotted to the petitioner. That is what's in possession. We have allotted it. I have got no dispute to that. Your Lordship.
So what the land law says, if the person has been given and he has been under possession for such a long period, what the law says?
Your Lordship, the possession of the land. Possession of the land.
He was under the continued possession of the land
Yes.
for about 40 years.
Yes, Your Lordship. So the possession of the land was 0.67 acres. We have allotted that to the petitioner, Your Lordship. We have allotted that. Has the petitioner challenged that, Your Lordship? No.
No, all the document shows that he was under cultivation. he planted the banana trees and all.
His father planted.
His father planted, but he continue carrying it on. So even after his father, after this special permit, even immediately after 4 years, his father expired. Thereafter, his son was, the present petitioner has been under possession.
Yes.
Hmm.
So your lordship.
Now, what the law says regarding this, regarding the possession.
Yeah, then in that case, your lordship,
Hmm.
is the petitioner under 226 or is this court can decide on the titleship?
No.
Then the petitioner.
Title cannot be. Title cannot. If it dispute of fact.
Because
Cannot be.
he's claiming compensation.
That
on
is
the
why,
ground that he
that is
don't-
why, that part this court will decide
Ah.
whether this court can decide or not.
Yes, your lordship.
But then for the time being, my query, just to know, what is the law, what the law says. If the person is under the possession of the land for say around, in this case, 40 years,
Yes,
without disturbance from anybody, and he was of course under the permission.
yes.
So can it be claimed without
So your lordship,
claim back?
my answer to that query is the land that was in possession of the petitioner, that was in possession, that land has been allotted to the petitioner by this order that 25th of February 2020. The land that was in possession, your lordship, look at this report. Where is the petitioner in possession?
No,
your
that
lordship?
is thereafter only. That is thereafter only. Afterwards. I'm talking about the 71 to till this 18.
Where is it? Where is the petition? He is selling off the plot of land. How is it in possession, your lordship? He is selling off.
No, he was under possession. That is why he thought that he the owner of the land, and that is why he sold.
See, your lordship.
He gifted it.
Yes, agree. Agree.
No,
Agree. Your lordship. If he is the owner of the land, let him show by what document he is the owner of the land. By what document?
no. You say that he has sold during this period. He cultivated some part. He has gifted it, gifted some part of the land away to somebody, some individuals, and he has also sold some part of the land, also substantial portion of land.
Yes.
So I'm curious to only know
Yeah.
what is the law, what the law says regarding the long possession of the person in Nagaland. What the law says. Let us, for the time being, I agree with you, whatever you submit, no dispute. But then regarding the possession, what the law says in Nagaland.
Your lordship. The issue of possession will arise only when the petition is in actual possession of the land. The petitioner is not in possession of the land. He has been selling it off. What was the question of the
See, why I'm saying so is that because he was under the possession, it shows from the selling also. He sold it because it was under his possession.
He presumed to be the landowner.
No, presumption, presumption that land belongs to somebody, I presume that land belongs to me, that land, presume that land belongs to me. Or that, can you purchase that one? No. So he was under the impression that this is.
Correct, under the impression that, yes.
This is under his possession.
Yeah.
He has a lawful right over the land. Okay, but it was under his possession. It was, of course, physically possession. He may not be cultivated. In some part, he was cultivating, but then he was under the possession in his mind, or in the land also. In some part of the land, he was under physical possession. Now, of course, because there was a lot of land, some part still there is some 7 point something. He also is probably not realized.
Yes.
This land belongs to, this land also covers under his, under the permission. So what the law says so forget about this land. You just try to,
That is not.
in a Nagaland,
Yeah,
what the law says, if the person is under possession for more than 40 years,
The law.
without any dispute.
Your lordship, see, the law might have said anything else. But the issue here, is, your lordship, the issue here is, see, for instance, your lordship, let us say that if a person is in possession of
Just a minute. Take a break for just one. So what according to you, the law says?
Your lordship, in this case, since a permit.
Not in this case. The possession.
So far as possession is concerned, if it is a traditional.
Nagaland.
Traditional system, if it is given, no reason, without any reason, it is just.
Given to?
For example, if it is given to me,
Huh.
even if it is a gift also, traditionally, it is taken as already given, and even the owners will not raise.
Claim back.
Because, yeah, customarily, it is always done like that. So here, in the unique position here is the government gave this land to my father by way of a permit. Here,
Yes.
now,
Now, here, your father was given a permission, a
Yeah.
permit. With that permit, you continue possessing
yeah,
till 2018. So that is 71, 2001,
I've been since 1971.
more than 40 years.
Yes, I have been fighting over.
More than 40 years. So this situation, what the law says under such circumstances, the customary laws in Nagaland, what it says.
And it is provisional.
Hmm.
Then the permit itself must clearly specify the time period. But here, it was,
No limit.
the government understandably asked for the permit because of the petitioner's father's contribution.
Yeah, that is there.
They-
No time limit.
No time.
Hmm. No, that is another. But I just wanted to know what your customary law says regarding this possession, long possession, because the law, long possession, if
Yes.
undisturbed,
Can the
it's
government land,
32,
can the government
12
land?
years, 12 years,
be
12 years or
from
something.
From a customary.
No, just a minute. There's a 12 years or something.
Land. Can it be owned
Hmm.
by, in the way of.
If the person is
Project.
under the continuous possession of the land without disturbance
Yes,
for 12 years, probably
Yes.
Assam land,
yes. As per
Laws.
the Assam land revenue.
Land
regulation,
revenue,
those
laws.
are also-
So that I wanted to know, as per the custom of in the Nagaland. Okay, anyway, just let us come back. I just wanted to know that also.
Yeah, because as far as the customary law is concerned,
Hmm.
customary law will prevail
Hmm.
when I have a custom and in another individual, I'm giving it to that individual. That is a different story. Here is a land where it belongs to the government. How can the customary law prevail? Or how can the customary?
No, I just wanted to
prevail?
know the
Yeah,
customary, and then as per the Assam, which land law governs it?
Only in Dimapur, your lordship.
Yes.
Only Dimapur, a small area, it comes under cadastral surveyed land. The rest, they belong to the Nagas. It may be a tribe, it may be the village, it may be individuals, but customarily,
Hmm.
now, if the customary law applies here, whoever has been in possession since ancient times, they are the owner, they are recognized as the owner, and the government can only acquire the land from the individuals if they need the land for the developmental purpose or a specific purpose which is permitted under the Land Acquisition Act. Then in that case, the government may acquire the land from the individuals and pay reasonable compensation under the Land Acquisition Act. But
In the present case, land was not acquired, it was given to, donated to the
in fact,
government.
it was not the Chabuka village alone which donated the land.
Okay,
Initially, I have given, in the first. Here, it was.
okay, that part will,
Where
that part will,
villages, the surrounding villages, they agreed to donate land to the government because of, through the intervention of the petitioner's
Okay.
father. And
Okay.
then
Hmm.
they wrote the land. The actual allotment by the Chabuka village was done only in 1980.
okay,
That's
Okay.
what government, the land which I occupy.
okay, that part will come back, that part will come back in your, yes, please, yes,
Now, complete this.
yes. Let us complete yours.
no, your lordship, as I was saying, your lordship, possession, yes, I admit possession. A portion of land that has been allotted to the petitioner He was in actual possession. He was in actual possession of that land because his building stands there, his house stands there. We have not cancelled the allotment order by throwing him out. We have allotted that portion of land which was.
See, 150 also, almost 158 acres. Now, according to you, that he is under possession, not even 1 acre,
No, Your Lordship. We did not.
only 6, 7.
We did not dispose him of 154 acres. He himself
Hmm.
sold it. How much, Your Lordship? How much? 94.01995 acres has been sold
Okay.
by him. Out of 100, Your Lordship is talking about 157. I agree.
Hmm.
Out of 157, he himself has disposed 94.0195 acres. That is why more than half of the area he has disposed it, Your Lordship. How is he in possession?
Okay, so treating this, what would be the consequences about this 94 acres?
That is why, Your Lordship, that is why the government has, through this impugned letter, has decided what to do with this, with the remaining.
So that will be cancelled.
Some, yes, where there is no building done, no nothing, no allotment given, but no structures there, has been cancelled. Those has been cancelled. We are not, see, Your Lordship, though the petitioner, please try to understand this, my lord. Though the petitioner is not the owner of the land, he still cannot prove it that he is the owner of the land. Just because he assumed that he was in possession of the land, and therefore he is claiming ownership. Besides that, Your Lordship, there is no document. I have given enough submission on it, Your Lordship.
Yes, yes.
Yes, Your Lordship. He cannot even produce a single document showing that the mutation has been done.
No, that's,
mutation has been done.
he's
Nothing,
not claiming,
Your Lordship.
he's not claiming.
Yes. So, Your Lordship, how is he the owner? If that is not done, even then also, Your Lordship, whatever land that the petitioner has sold and the pata has been acquired by those individuals from the district election, we are not touching that. We are not touching that.
Okay, to whom the
Yes,
government has already allotted.
yes. And sold by whom? By the petitioner.
Okay, you are not touching
We
that.
are not touching them.
Okay.
Look at our letter, the impugned letter.
Mhm.
We are not touching them, Your Lordship.
Hmm.
In spite of the petitioner not having a single right to sold off the land, Your Lordship.
Hmm.
The government, though he has sold it off, we are not even asked. In fact, it's the government who should seek compensation from him,
Hmm.
Your Lordship. Without Your Lordship, see, in the village, I do agree with my learned friend.
No,
In the village,
no,
Your
in
Lordship.
respect of the others also to whom the government has allotted, that also in the same line you have allotted these people.
Yes,
Although of course, these individuals have approached the government for allotment
Yes.
based on the purchase
Yes.
they have made from the petitioner.
for the petition.
Hmm.
We have
But-
allotted, Your Lordship. We have allotted. We are not cancelling those.
Okay.
Look at our letter. Look at, of course.
Now, what about the last, he has submitted this last representation
Yes.
for the negotiation. What is, praying for settlement? No,
Yes.
last
Renegotiation.
renegotiation. What is your reaction on that?
Your Lordship, we have not taken any, Your Lordship, it has been decided now.
Hmm.
It has been decided now. Renegotiations, after it has been decided, Your Lordship.
Hmm.
It has already been decided.
That
And
there will be no renegotiation on the matter.
as of now, Your Lordship, we have not, we might not have acted on this representation. I have got no information as to whether the government have acted on it or not, but probably the government have not acted on it, so maybe the.
Let us see, what is his proposal here in the renegotiation?
Your Lordship is saying, Your Lordship, if I may take my Lordship to page 89.
Here he claims that it was gifted to him.
Yes.
Okay, so you have an objection that it
Yeah, no gift.
is
Yes.
gift is not complete.
No, Your Lordship. He cannot.
So let us see what is his
He just
proposal
said,
here.
Page 89, not para, Lordship. Therefore,
Hmm.
it starts with therefore. In view of the above facts and circumstances in the interest of justice, the impugned arbitrary order dated 24/9/2018 and 25/2/2020 may be questioned set aside forthwith and award appropriate rate of compensation to the applicant petitioner for taking over my land without my consent by way of establishing government offices, besides legally issuing land permit to many individuals and organizations behind my land. Therefore, taking into consideration the aforesaid mentioned facts and circumstances in its entirety, the applicant petitioner hereby appeals your company authority to kindly settle the matter amicably once and for all with the application of is again seeking compensation, your lordship.
So he is seeking compensation against a part of land which you have allotted according to him without his permission.
Your lordship.
No, according to him, without his permission, isn't it? Seeking compensation for the land which you
Yes.
have allotted
Yes.
according to whom, according to him, which was allotted by you without his permission,
According to him.
according to him.
According to- what-
So
what is
his,
permission?
his claim of compensation is limited to that part, it appears. Because rest of the lane, 76 point so and so, and the 17 point acre, which consists 94 plus acres, is done by him.
Yes.
So against that, he cannot.
He cannot.
He cannot, because it was disposed of by him only.
Yes.
But the rest of the land which you have allotted according to him, which you have no right because it's his land.
Yeah.
So he is claiming compensation for that land. Okay.
But for that, your lordship, he has to show that the land belongs to him.
Hmm.
Just because, your lordship, he assumes that
Okay.
that
Now,
land-
apart from this compensation of the land which you have already allotted, whether, what is his claim about the present land? How much of land at the moment he is claiming?
4.43 acres.
4.4.
Yes.
This is untouched land only? Or what?
Yes, this land permit was issued
To somebody,
to
some individuals?
individuals, which this district administration has cancelled.
Okay. So this permit was granted to them based on what? Is this also the part of the land which he had sold to individuals?
No. your lordship.
Okay, this is different.
Yes.
Okay, the permit was granted by the government,
Yes,
so
but no construction done.
no construction done, and then you have cancelled.
So we have cancelled.
Okay.
We have cancelled that.
Now, in and around the present possession of the physical possession of land, 0.67 acres,
Yes.
whether he has also some other land
No,
beside,
that
only
is-
that portion,
That is the actual possession. and we
actual
have to
possession.
complete
And this 4 point some acre is lying
that.
at some distance,
Yes.
not nearby.
No.
Okay.
So that portion, that is why, your lordship, I'm saying this.
Hmm.
If a person is in actual possession of the land for a long period of time, maybe at that point of time, the person may accuse someone. Only for those areas which is in his actual possession.
Is 0.67.
Yes, this is what I was trying to say earlier, your lordship.
Hmm.
0.67 acres. This one is in actual possession of the petitioner. We have allotted that, your lordship. The rest,
What about that talk about the ponds also, ponds under his
your
possession?
lordship, it is mentioned.
That also comes under this.
And his fisheries pond measuring 0.67 acres is within the area.
Okay, the pond
Yeah. and his-
is also within this
Yes,
0.67 area.
yes. So that, and that also, your lordship.
It's not even 1 acre.
Your lordship, it is not in feet, it is in acres, 0.67 acres of land.
The point, not even 1 acre.
Lordship, even that also, your lordship, see, even that also,
Okay.
without having any substantial documents showing that the land belongs to him.
Hmm.
That allotment itself has been.
Okay, anyway, why I'm asking is because there are a lot of confusion because he was permitted, you have allotted without cancelling the permission, and subsequently you have cancelled report, all those. These confusions are there. So that is why
Yes,
you have to reassess, we ask again and again in order to assess
I understand.
assess as to what actually you have acted somewhere which you shouldn't have actually. Before cancelling, you shouldn't have allotted. And you shouldn't have sold portion of land, okay, unless he acquired it by allotment or getting mutated in his name. So both sides have done something which the law doesn't permit.
Your
So that is why some negotiation is required in this case,
Lordship,
it appears.
Lordship, I agree with my lord on
Hmm.
that point.
Because the act which you have done
Yes.
without cancellation is against the law again. So the act which he has done
No,
without your
Lordship.
permission is against the law again. No, because unless it is cancelled, you have no right.
No, your lordship, this impugned letter was issued only after the cancellation. Only after the cancellation of the permit.
No. The allotment was done there before cancellation, it appears. Some of the allotment.
See, your lordship, I agree.
Earlier you have submitted that.
I agree on that. Your lordship. See, your lordship, my final submission will be this.
Hmm.
Your lordship. I have given a special permit to the petitioner
Yes.
for a particular purpose.
Hmm.
I have shown by way of citation that when a document is being placed,
Hmm.
the document has to be read in the line that it's been written. Different interpretation may come, but how and the words that has been used in the document, that has to be
No,
taken into consideration.
see, that is why
Beyond
I'm
that-
saying during the existence of the permission, during the persistence of the permission, you have also no right actually
No.
to allow without taking permission from him,
Allow me
to whom you have already permitted.
Allow me to conclude, Your Lordship,
Yes.
with this. I have just given him the permit for cultivation, not beyond that. Yes, I
Maybe,
admit,
maybe.
Your Lordship, I
Yeah.
admit.
Hmm.
If at all, basing on that particular permit, if the petitioner approached the administrative authorities
Hmm.
for mutation of the land in his name,
Hmm.
and if that's been done,
Hmm.
Your Lordship, the action of the government selling off this land or giving it to private individuals by allotting, that will become wrong. There will be wrong action on the part of the government. Here, no mutation whatsoever has been done. Yes, the permit, Your Lordship, for some reasons, which was given to his father, continued. And in that continuation, Your Lordship, the petitioner, without getting the mutation or the allotment order, has sold off their plot of land. Now the question is, Your Lordship,
Can you just once see when the allotment was given, when you started giving allotment to the individuals?
1988, from
88.
1988.
See, the cancellation was done only in 2018 only.
Your Lordship, 1988 allotment has started. Has the petitioner approached the court then, Your Lordship? No. Has the petitioner impugning those allotment order? No.
So that you see, that allotment,
is the grievance of the petitioner.
that allotment was granted by you during the subsistence of the permission, which special permit which you have granted to
Okay,
the
Your Lordship,
petitioner. That is why
maybe-
both sides has
Maybe,
committed.
Your Lordship, maybe.
Hmm.
But is that a disputed fact here? No. In this present, is that a disputed fact? No. Is that what is to be decided in this jury petition? No.
The dispute of fact cannot be decided by this court. Agreed. So that is why I'm trying to analyze what is the dispute actually, because both have committed mistake.
No,
And now you are claiming, he is also claiming, and the third person is also claiming.
Your Lordship,
allow me to submit a
Hmm.
decision.
No,
of the
just
Supreme
let him
Court with
conclude
regard
first.
to-
Let him conclude first.
with regard to the scope of the present writ petition, what is the scope of the writ petition? Where it generated, whether it can metastasized into a cancer like which they are doing now. What is the actual scope of the thing? I would like to submit on the basis of a Supreme Court decision.
You want to conclude
So
first?
if you want to conclude-
Okay, let him conclude first. Let him conclude first.
So now, Your Lordship, since there is no allotment order or any mutation done in this, still the petitioner is claiming to be the owner. I say, I have given the land to you for cultivation purpose only, and therefore I hold the land. Your Lordship, the land belongs to me. I say this, the government is stating this, and therefore whatever allotment has been given, we have started cancelling it. Now, Your Lordship. So now, the issue as far as the compensation is concerned, that can only be decided when the ownership title has been declared. And that the petitioner has to approach the civil court below to decide on that. As far as the other prayer is concerned, they have only impugned the consequential order. The basic order has not been challenged. And since the basic order has not been
Yeah,
challenged.
that you have already
that-
submitted. That
yeah,
you have
the
already
first prayer is gone.
Hmm.
Only with regards to the compensation, Your Lordship, that can be given only when the petitioner can prove that the land belongs to him. And for that, Your Lordship, the petitioner has to approach the civil court, not
Okay.
sitting under 226, Your Lordship. Your Lordship is well aware. Your Lordship knows more than me.
No, I don't.
So, Your Lordship, it cannot be, as far as the ownership is concerned, Your Lordship.
Yeah, you have to prove.
Yeah. Yes.
Your
Yes,
case.
prove.
Hmm.
And this is not the right forum, Your Lordship. The Lordship is well aware of. I have got no further submission.
Okay. Yes.
Yes, I will not take that much time. I will just bring it back into focus about what we are dealing with right now, Your Lordship.
Hmm.
Because the learned government advocate has taken you through all the rabbit trails which are not relevant to the instant case, Your Lordship. So I'll take
Okay.
Your Lordship to a Supreme Court decision.
Okay.
This is 2013, volume 10, SCC, page 95, Your Lordship.
Just a minute, huh?
I'll take Your Lordship. This is a case where I'll take Your Lordship to
Just a minute.
starting because the facts of this case are quite relevant. That is why I'll take it. But the ratio, the principles laid down are at paragraph 6.
Just a minute. Huh?
Yes.
Okay, good. Yes.
Starting from paragraph 6, 7, 8, 9, 12.
Just a minute. Huh? Hmm.
Sorry.
This is regarding?
This is regarding
Just a
the
minute. Huh?
scope of the read which we are dealing with. When one court has already concluded.
Para? You said para?
I'll take a look. I'll specifically confine to paragraph 2, 3, then 6, 7, 8, 9, and then 14 and 15, Your Lord. 14, 15, 16. Because these facts are very important here. Your Lord. If I may read from paragraph 2.
Yes.
This was with regard to invitation to tender and issue arose. So it came before the learned single bench on 2 issues, 2 main issues. One was left out, only one, based on one, the decision was given. Then what happened was, in the division bench, the second, in the division bench also, the learned single bench decision was upheld. Now the Supreme Court, before the Supreme Court, new grounds were raised. Issues which were not decided in the single bench. Before the single bench, they were raised, the court said, no, you cannot do that. What is the basis, what is the foundation? The learned single judge has already decided, we have to confine only to that. That is the grasp. So allow me to read, Your Lordship. Paragraph 2. The 2 terms of the subject, invitation to tender, which are germane to the case in hand are clause 1 and I and J thereof, which read thus. 1. A declaration in the form of affidavit in a non-judicial stamp paper should be submitted stating clearly that the applicant is not barred, delisted, blacklisted by any government department, government in the undertaking, statutory body, municipality, and of the like government, bodies in DI pipe supply tender during last 5 years, and if any such incident is found at any point of time, the tender will be cancelled summarily without assigning any reason whatsoever. K, valid. PAN number, copy of.
How it is connected?
Yes. Acknowledgement of latest income tax return and provisional tax return. Now, number 3, it is important. It must immediately be clarified that so far as clause I is concerned, the learned single judge had thought it unnecessary to analyze it. That means it was not necessary, so nothing was left out. Applicability and relevance, having come to the conclusion that a violation of clause J had been committed by the appellant company in as much as it had failed to file its latest income tax return along with its fee. This position has continued to object even before the division bench, as will be palpably clear from a perusal of the impugned judgment. The division bench, despite knowing clause J, has concerned itself only with the legal implications flowing from the alleged non-compliance with clause I. Now, 6, Your Lordship. The respondents have endeavored to raise the alleged violation of clause I before us, but we are in no manner of doubt that this effort should be roundly rejected. This is despite the fact that an explanation, even in this context, has been offered by Mr. K.B. Vishwanathan, learned senior counsel appearing for the appellants. We shall desist from making any observation in regard to this clause J, since it does not feature in the analysis of both the courts below. The two courts below have not taken that into consideration. Only one issue is there. It has to be, the Supreme Court has to confine only to that issue. That is what the Honorable Supreme Court has said. Now, 7. This court, and even more so the High Court, as well as the subordinate courts, have to face lengthy arguments in each case because of the practice of citing innumerable decisions on a particular point of law. The correct approach is to predicate arguments on the decision which holds the field, which in the present case is Tata Cellular versus Union of India, rendered by a 3-judge bench. The rule of precedence, which is an integral part of our jurisprudence, mandates that this exposition of law must be followed and applied even by coordinate or co-equal benches, and certainly by all smaller benches and subordinate courts. We hasten to clearly clarify that if a coordinate bench considers the ratio decidendi of the previous bench to be of doubtful efficacy, it must comply with the discipline of requesting the Chief Justice to constitute a larger bench. Furthermore, there are some instances of decisions, even of a single judge, which, having withstood the onslaughts of time, have metamorphosed into high authority, demanding reverence and adherence because of its windage and following in contradistinction of the strength of the bench. This is a significant characteristic of the doctrine of stare decisions. That means the decision of a single bench, as it has, if it has withstood the test of time, will even be applied by all the courts. That is what it is saying. Now, here in this case, there is a decision of the court. I'll take your lordship to that. What is the parameter laid down by that decision, and based on what document that decision was made? It holds the appeal. They have not filed any appeal. They cannot go beyond the confines of the scope laid down by the High Court in the earlier revision. The subsequent inquiry committee which was set up ought to go according to the direction of the learned single bench, and also decision is to be made within the parameters of the learned single bench decision. Here in this case, they have metamorphosed it into a cancer, adding things which are not there in the judgment of the learned single bench. That is the question I am raising here. And if they have gone beyond the scope of the parameters laid down by the learned single bench in the judgment, then in that case it becomes void. Because they have to confine the inquiry and the decision within the parameters laid down by the learned single bench and the Chief Secretary's letter. The Chief Secretary's letter is very clear, is very clear, directing the Deputy Commissioner. Based on that, this Honorable Court has also directed the Deputy Commissioner to make the inquiry, submit a report and take action accordingly. Not to go into all these areas, whether the petitioner is holding valid permit or not, that is not in question. The permit, it is admitted by the government. Now they want to say that when the Chief Secretary has said that the subsequent administration should honor the earlier administration's order. So how could you have allotted all this when he is in possession? All those has been done. So conduct an inquiry, bring the report, so that I can make a proper decision on it. That was the parameter laid down. High Court, this Honorable Court has also, based on that, given the direction to do accordingly. They cannot now come before this Honorable Court with all these different findings. Where is his permit right? What permit gives him ownership? All these are now past. It cannot be raised at this stage. We have to go by the Secretary, Chief Secretary's letter and the order of this Honorable Court in the earlier case, the judgment. It has to confine to that. Whether the subsequent acts which were done in pursuance of the direction of this Honorable Court is in accordance with the court order or not. That is the only question. If it is not, then it is to be questioned. That is the position. That is why this case is of importance here, Your Lordship. And paragraph 8, if Your Lordship, it is a capital exhaustion of court time, lack of which has become critical. We shall therefore confine ourselves to Tata Cellular. We are mindful of the fact that it is a legitimate exercise, perfectly permissible for the benches to advance the law, provided this exercise does not lead to a conclusion which is irreconcilable with a binding precedent. We also would clarify that the manner in which a bench appreciates the factual metrics before it can obviously be of value only if a subsequent case presents identical facts, which remains a rarity. 9. Tata Cellular states thus. 77. The duty of the court is to confine itself to the question of legality. Its concern should be number 1, whether a decision-making authority exceeded its power. Here I am saying that the decision-making authority has exceeded its power, committed an error of law. 3, committed a breach of the rules of natural justice. 4, reached a decision which no reasonable tribunal would have reached. Or 5, abused its power. So the question before this Honorable Court is whether the decision-making authority has exceeded its power, whether it has abused its power, whether it is in accordance by going against a specific order judgment passed by this Honorable Court in an earlier case, based on which all the subsequent steps were taken, and because it went against that, I am before this Honorable Court challenging it. If it is found that all their exercises were not in consonance with that, it is void ab initio. It is void, Your Honor. It is beyond jurisdiction. Even though it is not even challenged also, it is void. That is my case. Now, therefore, it is not for the court to determine whether a particular policy or particular decision taken in the fulfillment of that policy is fair, Your Worship. It is only concerned with the manner in which those decisions have been taken, Your Honor. In the manner which they have proceeded. That is more important. The extent of the duty to act fairly will vary from case to case. Shortly put, the grounds upon which an administrative action is subject to control by judicial review can be classified as under illegality. This means the decision-maker must understand correctly the law that regulates this decision-making power and must keep effect to it. The law here is the judgment of this Honorable Court. Number 2, irrationality. Irrationality, namely whimsical unreasonableness, procedural impropriety. Here, All these three have been violated. Because the law now in place is the single bench, this honorable court's decision, based on which all these subsequent inquiries were undertaken. Now, I'll take your lordship to paragraph 14. Page 104. So far as the first point is concerned, it needs to be dealt with short shrift for the reason that the courts below have not thought it relevant for discussion, having in their wisdom considered it insufficient.
You're reading paragraph?
Paragraph 14, your lordship.
Yes.
So far as the first point is concerned, it need not be dealt with short shrift for the reason that the courts below have not thought it relevant for discussion, having in their wisdom considered it sufficient to non-suit the appellant company for its failure on the second count. It has, however, been explained by Mr. Vishwanathan, learned senior counsel for the appellant company, that all the materials time there was no blacklisting or delisting of the appellant company, and that in those circumstances it was not relevant to make any disclosure in this regard. The very fact that the tendering authority, in terms of its communication dated 22/7/2013, had not adverted to this ground at all, leads credence to the contention that a valid ground had been proffered, valid argument had been proffered, had this ground been raised, regardless of the weight, pithiness, or sufficiency of the explanation given by the appellant company. In this regard, this issue in its entirety has become irrelevant for our cogitation, for the reason that it does not feature as a reason for the impugned rejection. This ground should have been articulated at the very inception itself. And now, it is not forensically fair or permissible for the authority or any of the respondents to adopt this ground for the first time in this second salvo of litigation by way of sidewind. So here, in the first writ petition, all these issues were never raised. They admitted to everything. So now that they were not considered. All this that the learned government advocate has been presently raising, they were not raised in the before the single bench, before the earlier court. The earlier court confined itself based on the affidavit and the affidavit filed by the state respondents and the order passed by the commissioner and chief secretary, the then chief secretary. Based on that, the judgment was passed. These issues which they are raising now, presently, was never raised in the before the learned single bench when the matter was decided. They are raising these issues only now, making a very passionate appeal before this honorable court that he has no right. When in that first petition, they have already admitted that I have the right. Only thing is to protect my interest. And in order to protect my interest, inquiry be conducted, submit what are the encroachments that have been done. That was the direction of this honorable court. So now at this stage, they cannot raise the new issue. They have to confine themselves to the earlier this honorable court's judgment and order. As simple as that. And whether the proceedings that they have already applied is in consonance with that or not. If it is not, then it is beyond jurisdiction. Then it becomes void. It cannot be applied at all. It becomes void. It cannot. 15. The impugned judgment is indubitably a cryptic one and does not contain the reasons on which the decision is predicated. Since reasons are not contained in the impugned judgment itself, leave that. But 16, Your Lordship, the following observations found in the celebrated decision in Mohinder Singh Khel versus Chief Election Commissioner are relevant to this question. The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. And otherwise, an order back in the beginning may, by the time it comes to court on account of a challenge, get validated by additional grounds later brought out. We may here draw attention to the observation of post J in Korbandas, Panji. 9. Public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanations subsequently given. Here they are trying to give explanations subsequently given by the officer making the order of what he meant or of what was in his mind or what he intended to do. Public orders made by public authorities are meant to have public effect and are intended to affect the actings and conduct of those to whom they are addressed and must be construed objectively with reference to the language used in the order itself. So here in this case, the Chief Secretary clearly said that what order was passed earlier allowing the petitioner further the land permit, special permit, it was because of his assistance to the government. It was because of his assistance to the government. So, and subsequent administrative officers, whoever come, must respect the decisions taken earlier, must uphold it. So now it is, I am being I am being informed that the state itself, the administration itself is allotting land which is his. This is not proper. Inquire, submit report. That was the Chief Secretary's order. Now by subsequent, while giving effect to that, they have decided to bring in new things and try to explain it away by way of an affidavit. This cannot be done. It is not a cancer. They have made this issue into a cancer where they can do anything, say anything, put anything, and then muddy the water to such an extent that everything is distorted. That is what they are doing, trying to do, Your Lordship. It cannot be done. They cannot explain it. Now, they have to base the inquiry on the basis of the Chief Secretary's letter, which I'll take the Lordship to again, because it is very important, Your Lordship. This is the foundation. Page 40. Page 40, but I'll take the Lordship to page 42 because this is the clearer typed copy. It cannot, this inquiry cannot go beyond this, Your Lordship, and the judgment which was passed by this Honorable Court based on this. This is dated 18th July 96. A representation has been submitted to me by L. Nokman Wangshu, son of late Nokman Lokten Wangshu, alleging that illegal encroachment has taken place in the land given to his father, which he has inherited. This special permit for farmland at Dizit was given to late Lokten Wangshu, the then RCM, and the area given to him was properly, this is alienated. In course of time, encroachments had taken place by police department, industry department, and also by private individuals through permits given by administration at different times. The land given to late Lokten Wangshu, the then RCM, was in recognition for the assistance he has rendered to the administration and also for standing for the people in times of difficulty. Your Lordship, this is very important. Why it was given? In fact, without his consent, the Chief Secretary is clearly saying, in fact, without his consent or his successor, no land should have been allotted to any person or government department. The Chief Secretary is clearly saying it. The Chief Secretary is saying that this is land which has been given over to him, allotted to them because of their service to the state and the people. Nobody, not even the administration, can allot the land without his knowledge. It appears that no respect was shown to the permit holder, who was given the farm land by administration for recognition of his services, given to the government and the people. Even the Angs of Dizit area had consented to this, as the land falls within their jurisdiction. It is not only the so-called private respondent who has come forward. There are other Angs. There are many Angs over there. All of them have donated land. And out of that land which was donated by the various villages, the petitioner's father was allotted the land, Your Lordship. Now, the administration should always honor the commitment given by previous administration to keep its image in the eye of the people. Instead of protecting the privilege given to certain distinguished persons, if the administration allows encroachment by individuals or government departments, it does not show any good images before the public. You are hereby asked to conduct special inquiry and submit detailed report comments as early as possible. Does this talk about cancellation of the permit given to the petitioner's father? In fact, it is upholding the permit that it should not be disturbed. Submit a detailed report. How far encroachments have been done? Submit a report. That is the Chief Secretary's letter. Now the government is taking the stand that how can these, based on this permit, he make any claim over the land? When the then Chief Secretary has clearly stated this, Your Lordship. This is the foundation of this instant case. This is the parameter on which the inquiry is to be conducted by the Deputy Commissioner. And then based on this, after it is submitted, if there are encroachments, illegal encroachments, they should be driven out. If government has illegally allotted the land, should be compensated. I have every right to do whatever I like with the land. This is how it is recognized by this letter. Now they are going beyond the bounds of this. They are now bringing in new things. They cannot do that, Your Lord. Now, coming to the decision of this Honorable Court, based on this, page 50, paragraph 5 onwards, Your Lordship, because up to paragraph 4, it is the submissions of the Learned Counsel. I have heard Mr. Supu Jamir, that is paragraph 4. Learned Counsel for the petitioner and Mr. K. Wotsa, Learned Senior Government Advocate appearing for the state respondent. So, submissions are above. This is the conclusion of this Honorable Court. This is very important. The context is clearly laid down here, paragraph 5. The grievance of the writ petitioner in this case is simple. The land in question was gifted to his father on 29/3/1971. Thereafter, in the year 1975, the circle officer prepared a memorandum on 11/4/1975, recognizing the same. If there is any encroachment, definitely, this is prejudicial to his legal and constitutional right, Your Lordship. If there is any encroachment, it is prejudicial to his legal and constitutional right. The Chief Secretary of the state, being aware of the situation, issued direction to the jurisdictional Deputy Commissioner way back on 18/7/1996 for holding special inquiry. There is no reason as to why the Deputy Commissioner would not hold the special inquiry as directed by the Chief Secretary. Although detailed reports after such inquiry was supposed to have been submitted before the Chief Secretary as early as possible, but the proceeding went hibernating without any valid reason, depicting irresponsibility on the part of the district administration. In the process, a proceeding before the Chief Administrator of the state has been stalled. Failure on the part of an authority in complying with direction of his superior not only betrays inefficiency of the administrative machinery of the state, but has also potential of sending wrong signal to the society as to the rule of law, which is so sacrosanct in a democratic set of governance. 6, although an affidavit in opposition has been filed on behalf of official respondents, the claim of the writ petitioner has not been disputed, Your Lordship. The claim of the writ petitioner was not disputed in the writ petition. In that petition, now they cannot bring in new things before this Honorable Court by submit new things by way of affidavit, Your Lordship. It is not permissible at all. The fact as to issuance of direction by the Chief Secretary is also not in dispute. There is no dispute about the Chief Secretary's order. This being the position, I feel inclined to allow this writ petition and direct the Deputy Commissioner Mon to hold special inquiry as was directed by the Chief Secretary by order dated 18/7/1996 within a period of 3 months from the date of receipt of certified copy of this order without fail and forward the same to the Chief Secretary for passing necessary orders. The Chief Secretary shall pass necessary final orders within 2 months thereafter from the date of receipt of inquiry report from the Deputy Commissioner Mon. So it is very clear. Even this honorable court has held that if any encroachments are there, if anybody has encroached on his land, it is a clear violation of his legal and constitutional rights. And therefore, inquiry should be conducted, and if his rights has been violated, it should be remitted, not to cancel all these allotments. It is not for cancellation of the permit given to him or raising objection about the permit. Just because the petitioner has written in a representation that it is a gift to my father, going into all those areas, it is irrelevant, Your Lordship. The permit has been recognized as a permit, special permit given to him, to the petitioner's father, and that it is for perpetuity, it is his. No one should touch it. That is what the Chief Secretary's clear letter, Your Lordship. Now the Chief Secretaries of the present times who have taken over charge cannot erase those facts. They cannot go according to their own will. So it is a very simple thing. The Deputy Commissioner is to conduct an inquiry. Inquiry was conducted, submitted. I am agreeing with that because in that report, what was suggested was take away the land from the petitioner, name a school or a road to honor the name of the father. Why should I not be agreed with that? That is the only report which is required under this, Your Lordship. No other subsequent reports are irrelevant, Your Lordship. Because we have to go by the Chief Secretary's letter and this Honorable Court's direction. This direction does not direct the administration to go for report after report after report. One report only, Your Lordship. That report was submitted. I am agreed with that. Is it in accordance with the judgment? This judgment dated 5/8/2014, or the letter or the order of the Chief Secretary. That is how it has to be tested on the basis of the facts and principles laid down in these two letters, in these two orders, one by the Chief Secretary and the order of this Honorable Court. This Honorable Court has to go by that only. It cannot go into all those rabbit trails which the learned government advocate has tried to lead this court around, beating around the bush, creating new things. No new things can be created. It is not a cancer. So many reports they have tried to make, one after the other, but the only one.
Based on this, which report was based on the direction of the court? Which report was?
This is the annexure K1, page 54. This is the only report. Annexure K1, Your Lordship, page 54.
So
this is the only report.
And based on this report, any order passed?
Based on this, no order was, but again, another special inquiry, another inquiry. The government was directing for inquiries over and over again, Your Lordship. All these other subsequent inquiries, they are based on this one inquiry. And I don't need to challenge all those other orders which were passed, Your Lordship. The only question is whether those things are as per the judgment of this Honorable Court and the Chief Secretary's order. If it is not, then it is void. The question of challenging a void order does not arise when it is beyond the bounds of the law that has been laid down, Your Lordship. This is the only one. Here they have clearly laid out how many areas, how many allotments the government has given. Only based on this, I am asking a relief that since as per the report, these many allotments have been given by the government, I should be compensated for that. That is my, because as per the Chief Secretary's order and the order of this Honorable Court, if it is interpreted in proper light, I am entitled to all this relief. Based on those two letters only. On those two orders only. The judgment and order and then the Chief Secretary's order. Nothing beyond that. No inquiry can proceed beyond that, beyond the scope laid down under that. All this cancellation order, it is void, Your Lordship. Without jurisdiction, not covered by the boundaries set by the Chief Secretary's earlier letter and this Honorable Court's judgment and order. It is void. When it is void, I'll take Your Lordship to a judgment when an order is void in itself and needs no challenge at all. When an order is void in itself, not within the jurisdiction, it needs no challenge. It needs to be only ignored and may be raised in collateral cases also. That is the judgment given by the Honorable Supreme Court. No, this is. No, I'll take Your Lordship to another, two more decisions. Can you? In the meantime, Your Lordship, about I'll take Your Lordship to one case. So far as the scope of this present writ petition is concerned, what is the genesis? What should be the basis? And beyond which, if the respondents try to submit, it should be rejected. All those submissions by the learned government advocate is rejected. It should be rejected because it was not placed, put up before this Honorable Court in that writ petition. They have filed affidavit in opposition. They did not raise these issues in the earlier writ petition. They cannot raise these issues now, Your Lord. It cannot be allowed as per the law. Now, another judgment, Your Lordship, when a law lays down such certain things to be done in a certain manner, because now the judgment of the Honorable Court, this Honorable Court in the earlier WPC, and the Chief Secretary's orders are the law now. When something is to be done in a certain manner, it has to be done in that manner and in no other way.
Well, where
That
is
is,
the?
I'll take Your Lordship to a SCC 2011-10 SCC 714, Your Lordship, 714. I'll take Your Lordship to the,
You have to give this also in print, the printed one, not the book.
all right,
Okay.
Your Lordship, I'll do so.
This is regarding?
This is regarding when a law says that something must be done in a certain manner. Now,
Yeah, that's-
here in this case, this Honorable Court's judgment has clearly laid down that the based on as directed by the Chief Secretary, the Deputy Commissioner shall hold a special inquiry and submit a report, based on which appropriate order shall be passed by the Chief Secretary. How they have gone beyond that? That is what I am saying. They cannot go beyond that. Now the clearly laid down direction is the law. So paragraph 32, Your Lordship, I'll just take this is with regard to statutory provisions, but it is now the judgment of this honorable court is the law itself, because it has not been challenged, it has now attained finality. Paragraph 32, it is settled law that where any statutory provision provides a particular manner for doing a particular act, the said thing or act must be done in accordance with the manner prescribed therefore in the act. Merely because the parties concerned were aware of the acquisition proceedings or served with individual notices does not make the position alter, when the statute makes it very clear that all the procedures modes have to be strictly complied with in the manner provided therein. Merely because the landowners fail to submit their objections within 15 days after the publication of notification under Section 41 of the State Act, the authorities cannot be permitted to claim that it need not be strictly resorted to. So it has to be, it has a process when it is clearly laid down must be followed accordingly. You cannot deviate from that, in short. In this case, specific direction to the Deputy Commissioner to submit a report. Again, after it reached the Home Commissioner, it is sent down for further reports. Again, over and over and over and over again. Just because the petitioner has submitted representation means nothing. It is what I am concerned with is whether the decision is as per the Chief Secretary's letter and this honorable court's judgment and order or not. That is my only case. If it is not, then it has to be questioned and set aside. All the proceedings. Nothing beyond that, Your Lordship. That is the law.
Where is the law which says that?
Your Lordship, now it has decision, it is going to come up, Your Lordship. When something is acted beyond outside of the jurisdiction. Here in the earlier judgment also I have cited the position where the paragraph, specific paragraph I have submitted in my earlier citation, Your Lordship, paragraph, it is paragraph 9. Paragraph 9, the duty of the court is to confine itself to the question of legality. Its concern should be whether a decision-making authority exceeded its powers. Here they exceeded their powers. Whether committed an error of law, committed a breach of the rules of natural justice, reached a decision which no reasonable tribunal would have reached. The first and the fourth one, it applies here. They exceeded the powers given to them. And secondly, they reached a conclusion which no reasonable authority could have come to the conclusion. So the only question is that before this honorable court. Now, with regard to void, I'll take your lordship to one citation which is 2021-19 SCC 629. Paragraph is
what is this about? This is regarding?
Void, when an order is void and it's not be challenged, your lordship. It need not be, one may only ignore it if it is not within the powers of the authority making that law. I'll take your lordships to paragraph 25. paragraph 25, if your lordship may, from paragraph 25 onwards. The page is 647.
Yes.
If I may, your lordship,
Hmm.
at this stage, it may be useful to keep in mind the purport of the expressions void and voidable. For that, we may advert to the exposition in Thurandar Prasad Singh versus Jai Prakash University, which had noted the dictum of Lord Tinning R in R versus Paddington Valuation Officer EXP Pitchery Property Corporation Limited, and also in Judicial Review of Administrative Action by D. Smith, Wolf, and Chauvel, and in Judicial Remedies in Public Law by Clive Lewis, the same read thus. 19. This question was examined by the Court of Appeal in R versus Paddington Valuation Officer XP Pitchery Property Corporation Limited, where the valuation list was challenged on the ground that the same was void altogether. On these facts, Lord Tinning MR laid down the law, observing at page 841 thus. It is necessary to distinguish between two kinds of invalidity. The one kind is where the invalidity is so grave that the list is a nullity altogether, in which case there is no need for an order to quash it. It is automatically null and void without more ado. The other kind is where the invalidity does not make the list void altogether, but only voidable. In that case, it stands unless and until it is set aside. In the present case, the valuation list is not and never has been a nullity. At most, the first respondent acting within his jurisdiction exercised that jurisdiction erroneously. That makes the list voidable and not void, and it remains good until it is set aside. T. Smith, Wolf, and Chauvel in their treatise, Judicial Review of Administrative Action, have summarized the concept of void and voidable as follows. Behind the simple dichotomy of void and voidable acts, invalid and valid until declared to be invalid, lurk terminological and conceptual problems of excruciating complexity. The problems arose from the premise that if an act, order, or decision is ultra-virus in the sense of outside jurisdiction, it was said to be invalid or null and void if it is outside jurisdiction. Here in this case, the jurisdiction is clearly laid down by this Honorable Court and the Chief Secretary's letter. The determination is only the extent of encroachments, illegal encroachments into the land held by the petitioner, and to remedy that. They have gone beyond that. It is beyond. They have gone beyond that and passed an order cancelling the permit of the petitioner. So they have gone outside the bounds. So it is void altogether. So it needs not be challenged even if it is void. That is the,
Okay.
yes, your lordship. So that is the position. My lord, your lordship, I have these judgments. If your lordship wants
Yes.
printed copies,
So what will do? There is other respondent also. We'll fix it on last. We'll fix it
Yes,
on
you're right.
next Monday.
yes.
Next Monday. Okay.
And since we're
We'll
regarding
finish
the
it off
facts and the
next Monday.
I have given in written, your
Okay.
lordship,
Hmm.
I need not submit again, go over the facts. In the
Yes.
earlier two petitions,
Yes.
so the persons who were directed to vacate the land were holding those property on the permission of the petitioner.
Okay.
It was not sold to them. So evicting them is evicting me. So the question of local standard does not arise there. And they are null and void, so long as the permit is with me. So these void orders, even I don't need to challenge that also, but as a formality, I have challenged it. It needs to go away. That is the only thing. So these are my humble submissions before this honorable court. The so-called decision to cancel the permit given to me is not within the parameters laid down by the earlier, by this honorable court in the earlier resolution. It has to be quashed and set aside. My prayer alone.
Mr. Ponga, huh? No, sorry. Mr. I've also had Mr. Angami, and Angami. You go Ponga for the direct counsel for the petitioner. The hard in part listed again on Monday. No? This submit again on next Monday. Huh? This is 15 minutes. Wait, this should be 15 minutes. 15 minutes. Okay. Probably this is 18 minutes.
May I please, your lordship, I'm appearing for respondent number 6.
Yeah, 15 is on Monday. You will be heard on Monday.
Lordship, I have Monday and Tuesday, I have a fixed hearing. So lordship, if I may be allowed to give my written submission, lordship.
Not properly audible also.
He wants to give a written submission on.
Lordship,
Written
Monday.
Okay, no problem.
So if I may
Okay,
be
no
allowed
problem.
my written argument,
Okay.
lordship.
Obliged.
Obliged, lordship.